out there. Yeah. Running. Disseminate. Who's bashing each other?
Matter, my lord, this matter pertains to Central Administrative Tribunal. That was heard at length, my lords. For further hearing, my lords, further in the sense, my lord, matter was heard at length, my lords. Substantially, it's heard, my lord, and thereafter, my lords, urgent for some reason. But
What is the reason?
but some clarification, my lords, sought by the
Who is appearing for the other side?
Madhukar Deshpande appears, my lord. Madhukar Deshpande.
Have you told him? What do you
Lord,
want?
I have informed him, my lords. I'll take his acknowledgement and answer.
Yes, sure.
May I request, my lords, any date short?
Suit for partition and separate portion.
What is the urgency?
Lord,
What is the date otherwise?
Lord, promotion matter relates.
What is the date?
Date, my lords?
Was it heard by us?
Not this bench, my lords.
Then-
Coordinate bench only, my lord. But now I am requesting, my lords, to kindly take up the matter because the matter relates to
A partner
promotion.
matter?
No, it is not a partner.
We have to check up. Please show us the order.
Please, my lord, I will.
It is a partner, it need to go there.
Please, my lord.
Getting the point. So we want to see the order.
Please, my lord.
Let's give it back.
Please, Miller.
Yes.
Yesterday, the
See, we are getting an impression as if we have heard the.
No. I'm not.
Should have clarified that.
Please.
please, Miller, yes,
Just 1 minute.
Suit for partition, my lord, or share. This trial court, my lord, decreed the suit in only item number 1, my lord, and dismissed the item number 7 to 9 and B scheduled property, my lord, dismissed. Therefore, difficult.
What, when was the decree passed?
My lord, on 23rd September 2022, my lord.
When did you file the appeal?
Appeal filed, my lord, 22/5/2023.
22?
22/5/2023.
Then was it not listed?
Listed, my lord.
When was it listed?
Already noticed, my lord, response
Sure.
has appeared. Yes, my lord. I
No,
published-
Eddie, what are the proceedings pending?
Yes, my lord.
What are the proceedings?
Now, my lord, she is unable to.
No. Before the trial court,
Trial court, my lord, dismiss it suit execution ಹಾಕಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ.
execution,
I don't know.
they have filed.
When is the date of hearing in the execution?
I don't know, my lord. So some difficulties,
Just
sir.
have
He is
couple
only
minutes, ma'am. See the
maintain the.
documents. Just check up the board also.
20th February.
Ma'am,
May I
just,
please, my lords?
no, but he has to inform the other side. Right?
We doesn't know even what they have filed in execution or not.
What can we do? But in any case, we have to give a date for the hearing. And just ask him to take an acknowledgement. Just ask him to take acknowledgement. Yes.
Other,
May I please, my lords?
It's an appeal. There was a suit filed for declaration and I was a defendant in the suit. It got decreed against me on 2/9/2022. Thereafter, I filed the appeal. And there was a order of this honorable court directing not to alienate or create third party rights. However, respondent number 3 has further alienated and there has been construction going on in the property. The urgency.
Was he any, when did he alienate it?
Your lordship, it was 14/6/2023.
Then where are we today?
2024.
Then-
I came on record only on.
Are we concerned with that?
Your
We are
Lordship,
concerned with the litigant, no? So he should take steps.
Your Lordship,
What is the urgency? Tell us.
the urgency is I have filed an application under Order 41 Rule 20, production of additional documents
Hmm.
showing the subsequent sale.
Just have it at your, whatever is convenient for us. We will have it on a convenient date according to us. Okay?
My lord, sir,
Yes, what do you want?
My lord, it's a fresh matter, my lord. I have filed on 16/12/2024.
Just one. The other side is appearing, na?
Madam.
Yeah. The other side is appearing.
I have served them through email. Yes,
You
they have.
will tell them the date also.
Yes, yes.
Take an acknowledgement. Yes.
My lord, this is a fresh matter, my lord. I have filed the appeal on 16/12/2024, my lord. Office objections have been removed, my lord. No caveat is filed, my lord. The matter.
What is the urgency?
Lord, there is no urgency, my lord, but
Okay, we'll give you a date,
yes, my
but
lord.
not,
Any convenient date, your
I'll
lord.
just give it in first week of March or so.
my lord, sir, 2023 writ appeal, my lords.
1 minute, ma'am. As he said, no objections. No objection. Okay. Put a full date. 2325. Yes,
2023 writ appeal, my lord. The respondent bank has initiated auction proceedings, much 50% lesser than the market value. Now I have filed to IAS.
where are we here? You should go to, is it pending before DRT?
No, my lords.
Was it a civil suit?
It is a writ appeal, my lord, civil.
Oh, it's a writ appeal.
Writ appeal,
What was the order in the learner single judge?
It was, I have no instruction, my lords.
Get that instructions, okay?
I have served the copy of the other side also. Regarding 31st, I have taken acknowledgement from the other side to hear the matter, my lords. There is urgency in the matter. Next week, they are putting the auction, my lord.
When was the order passed by the single judge?
In 2023, my lord.
Oh, then we will not allow this.
My lords.
We will not allow this. Don't come in your leisure.
No, the matter was pending before this honorable court. In the meantime,
No, have you filed the appeal here?
yes, my lords.
When did you file it?
2023, my lords.
It's pending.
Pending, my lords.
No date?
No date, my lord.
Then take it that.
I have filed IA also.
Yeah, we'll look into it. It's not a fresh appeal, no? It's a pending appeal.
Pending appeal.
Okay. Now you have to inform the other side.
I have already informed on
Please
31st.
give the date also.
The
Is the auction, then why do you come on a last date?
no, my lords, the auction is on 12th of this month.
12th of?
This month.
Then
Next month, next February 12th, my lords.
5th or 6th. Give.
My lords, my lords.
You will tell the other side also, inform the other side.
My lords, I have informed the date on 31st of this month. The matter will
No,
be.
you will take now an acknowledgement on this date.
I will inform the other side. my lord.
Yes. Yes.
my lord,
Yes.
this is a fresh matter, my lord. Under the SFC Act, I filed a commercial appeal, State Financial Corporation. A certificate for recovery of money has been issued where my residential property is sought to be sold by the corporation. The certificate was issued in November 24th. I have filed the appeal in December 24, my lord, because I'm living in that house, there's some urgency.
Any objections?
I complied with the office objection.
And it's not listed, the appeal.
No,
You're seeking listing. What is the urgency?
my lord, because they're taking steps to sell my residential property.
Was
I
it a
mean-
mortgage property?
Yes, my lord.
As a
My stand is
security?
my stand is the claim was barred by time, my lord. That claim is rejected.
Just give it, ma'am. Let's see. Next in February only. It's 6. Yes.
My lord, this is the commercial appeal of year 2023.
Mhm.
Now the settlement has already been arrived by the parties. The other
Just
side,
asking, 1 minute, sorry. Just asking,
Just
no
a-
objections, no?
No objections have been complied with, my lord.
All.
There is no other side also. Fresh matter.
well, this is the commercial
Has it-
appeal of year 2023.
My lord,
The settlement has already been arrived by the parties. Therefore, the other parties know about us moving this memo. My lords, we are moving this court hall to report the settlement.
But is any memo being filed or an application being filed? How would you?
My lords,
The other side need to be here, no?
my lords, the other side is aware about this because he was the party as well as the council were the
No, when we will dispose it off, we will take their submission also. That the settlement has been arrived at. Unless you file a joint memo, think over it. You want us to dispose it off. We can dispose off on the basis of your statement. Should not be contested at a later point of time. Getting? We will give you a date. Ensure it, the council is also here. Okay,
My lords. My lords,
just take it.
we sought a date for tomorrow. However, it is up to the convenience of the court, my lords. Any
It is
date,
not tomorrow.
any date the court feels.
Give it 5th or 6th.
6-2, sir.
Grateful.
Yes.
My lords, yesterday 3 matters served for regarding the promotion of Anganwadi helper to worker, my lord. One more connected matter is pending. Yesterday, your lordship directed me to file a memo. In that, there is no matter, no date is given. Yesterday, the date was given.
Who is the counsel for the state in that?
Yesterday, all the 3 were state and also present before the Honorable Court. Matter was served and directed me because of the to convenient, there is no date is given in this matter. And 27 is days were given.
Now, who are the parties here?
Parties are the
Same parties?
same parties, madam.
Counsel everything, just take it, ma'am. What is the date now there?
27-2, my lord.
Just have it on.
I mentioned all the,
Have it on 27 too. This is of 24?
please,
Let me just check up. This will be part,
23, my lord.
this will be ours only.
That is 2 orders, my lords. One is yesterday, it was listed, one more matter for the same party. Vimalakshi, please.
My lord, it's an RFA 2023 matter sued for declaration and injunction. On 2024 interim order was granted, so in order to vacate that hearing.
You have informed the other side,
Yes, my lord.
you take an acknowledgement also.
Yes,
Just give what is convenient, ma'am, in this.
requesting for 30th of this month.
We will see it. We have to see our board also.
Oh,
Sir, 20th February,
Next.
20th February.
Yes. The other side has been served. All are working, all are appearing. We will just give it whatever is convenient, March also. You'll take an acknowledgement from them.
Please.
Yes.
Contract. The suit has been partly decreed. A prayer for the performance has been rejected. Now the landowner is attempting to sell the property, the fresh market. Requesting
Is
for
there any caveat there
the KVL has served the KVL.
and objections? All complied? Everything? And just take that. Just see it first week, say.
That's a fresh matter.
They have to take acknowledgement, huh? Yes.
So, for specific performance, preliminary hearing memo. I see
No, what is the urgency?
I would see a
No, you are the plaintiff or the respondent?
respondent, my
Defendant.
lord. Respondent, my
So any decree against you?
in favor of me.
How? Then why are you filing this?
That my senior is given. For hearing.
ನೀವು plaintiff ಏನ್ರಿ ಕೆಳಗಡೆ
Respondents, my lord.
ಕೆಳಗಡೆ OS ಅಲ್ಲಿ
ಅಲ್ಲಿ plaintiff, my lord.
ಅಲ್ಲೇನಾಗಿದೆ ನಿಮ್ಗೆ
Decree ಆಗಿದೆ.
ಏನಕ್ಕೆ ಫೈಲ್ ಮಾಡ್ತಾ ಇರೋದು ಇದು
For hearing, preliminary hearing.
No, is it a pending matter? No.
ಅದನ್ನೇ
Who has
ಮೇಡಮ್
filed the appeal?
ಅಪೀಲ್ ಯಾರು ಫೈಲ್ ಮಾಡಿ
Who has filed the appeal? No, does he mention it for the?
ಆರ್ ಫೈಲ್ ದೊಡ್ಡಪ್ಪ
Which one? Did he file the appeal or who has filed the appeal?
ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ಯಾರು
Petitioner, my
ಅಪೀಲ್ ಎಂಟಪ್ಪ
You have
Appel-
filed it, you have filed it.
no, my lord.
Who has filed it?
Appellants.
No, you are respondent.
Yes, my lord, my lord.
So what do you want? Then why did you say petitioner?
ಏನೇನೋ ಬರ್ದಿದ್ಯಲ್ಲೋ
Check up, why did you say petitioner there?
ಹ್ಮ್
No, not even appellant, he's a
Respondent.
respondent. Yes,
My lord, serial number 22, the
we'll
matter
come
is
back.
settled.
My lord, suit for eviction and for damages, suit came to be decreed. I preferred appeal before this court and the pending. Now the execution is filed and now the attachment of movables has been issued.
Pardon?
Attachment of movables has been issued. On 7th of this month, attachment of movables has been issued. I moved before this honorable court and date was given on 10th. 10th, the matter is listed before the other coordinate bench, my lord, and other coordinate bench has posted the matter after 2 weeks. But yesterday and today, the matter again is not listed. Now the
Is
attachment,
the proceedings pending before the coordinate bench?
no, before this court only, the matter has to be posted. On 10th, this court is, division bench is not sitting, so that's the reason the
Oh, the
matter is-
matter went there.
went there. And
Now, what is the date now in that?
after 2 weeks, they will.
There is no date
No
there.
date. Now we
Weeks.
give the attachment of
Okay, when
movables.
was the matter listed before the coordinate bench?
10th of this month, 10th first, 10
It was
month,
listed on 10th.
10, please.
Okay, now it has gone to,
For 2 weeks, adjourn madadu swami. So afterward, there is not listed. So I thought yesterday and today, day before yesterday, it will be listed. Now there is an attachment of movables against me.
Madam.
We are tomorrow, my lord.
tomorrow
Please, because attachment of our movables are against me.
when is the execution listed?
The execution is listed on 23, but order is passed and yesterday they are been tried to attach the movables.
Any other mention? We'll come back. That will come. That's all. Yes, now start. Which is the number?
I pray your worship for making submission because I have not yet entered wakalas. Item number 17, my lord.
You're for whom?
Lord, today morning, Lord, I received instruction to appear
For whom?
for respondents, my lord.
Yes.
Item number 17, my lord.
Now, who appears for the appellant?
Lord, appellant up to one, Mr. Abhinav, Lord, as per the cast list.
Have you informed him?
But I am not yet informed, Lord, yesterday, today morning.
Then we will let the matter be called.
Serial,
Yes.
serial number 26, my lord.
Yes.
I am for the respondent.
Hmm.
Week's time to produce the arbitral record.
Who is the other side?
Present me.
That's the same, my lord's appeal. My lord's execution matter, this is already pending. It has progressed to the stage of sale.
Which matter?
My lord,
Say nothing. He wants to produce. You are the appellant.
Lordship has directed me to produce the arbitral record.
Yes, we have directed because we want that.
Please,
So you want, how much time you require?
weeks time, man.
The request, learner counsel for the appellant seeks time to, seek further time to produce the complete arbitral record.
lords, we were anyway ready today. We were anyway ready.
We don't mind, we want that arbitral record to be there. Possibly we have heard it, then only we have said so.
Please,
Yes.
please.
Just re-notify.
Lords.
Please, my lords.
Item 33.
17 to
My lords, may permit me to mention.
Item 33.
My lords, meanwhile, let the day of execution.
No,
which is
I have
going-
objection for that.
I'll
It
furnish
is
the
after hearing the matter, court has directed me to produce the arbitral.
1 minute. Why didn't you produce it?
Lordship has directed me to produce the document.
When was that?
Last date of hearing.
7 months.
Why didn't you produce it? Who was to produce?
Respondent, I have to produce.
Who was to produce?
Yes,
Then
sir.
why didn't you produce?
Lordship, I got the paper today only from the parties. It is they collect.
The execution is going, when is the date?
No, date is not on the 21st of December, February. my lord.
Meanwhile, I'll produce the case number, my lord, because,
By then he said 21st of February.
Please.
my lord, however, because it is, the stays there in sale. Every day, the officials are around my property, measuring the property for having it sold. Therefore, my lord,
But the date of, see, surely proceedings will be in the execution only on 21st, not
Please.
before that.
Yes, ma'am.
Have it. Next,
My lord,
Please,
serial number
my
22,
lords.
my lords,
just one. Yes, ma'am, what do you want?
My lord, your lordship may permit me to mention item 52 on your lordship's list, my lord. I appear for the appellant in this matter. I'm being led by the SD, my lord. And
For the first respondent in this matter.
yes, my lord, we've already informed the respondents as well. If your
Yes,
lordship could grant me a short
Yes,
accommodation. my lord.
what do you say on this?
I have no objection, my lord, provided a date is fixed subject to the convenience of this court.
Certainly, my
Ma'am,
lord.
you
As your
appear for
lordship.
the appellant,
Yes, my lord, I appear for the appellants.
just say that
Led by the SD, my lord, in this matter.
at the request of counsel for the appellant for an adjournment, which request is not opposed, adjourn to.
My lords, item 33, my lords.
I apologize, may I confirm the
2nd
date,
of
my lord?
April, madam.
My lord,
2nd
may I
of April.
may I request for the last week of February?
No,
Kindly,
no,
my
not
lord.
possible. Not possible.
my lord,
My lord.
I appear for the appellant.
Lord, would
in,
that be 2nd of February? I may just, if I may just.
Second is 2nd of April.
April, grateful, my lords.
My lords, appeal for the appellant in item number 22, my lords. So this instant appeal was challenging the dismissal of I number 12 and 13. But however, before the trial court, the parties have settled the matter before Lok Adalat, and the suit before the trial court has been disposed of, my lords, as settled. As such, the said appeal has become infructuous, my lords. So
Withdraw this.
I want to withdraw this instant appeal, my
Yeah,
lords.
this side.
Other sides here, my lords.
Just say that counsel for the parties state that the present appeal has become infructuous as the parties have settled. their
Before the Lok
differences.
Adalat, please.
Before the National Lok Adalat or Lok Adalat?
Lok Adalat, my lords.
Before the Lok Adalat. In view of that, the counsel for the appellant wishes to withdraw the appeal. Appeal is dismissed as withdrawn.
Grateful, my lords.
Lord, we have filed a memo for producing the Lok Adalat report, my lords.
Is it on record?
Yes, my lord.
Then wait. We will need to see it. Show us that.
My lords, for the
Just wait. Yes,
My
ma'am.
lordship, serial number 22. I am permitted
serial number 18, my lordship, and permit me to withdraw the MFA, my lordship.
Just wait for a minute.
Serial number 20.
Yes,
31 by that.
yes.
Today my senior, in the partner matter at Darwin, my lord, he's
The other side.
initial, my lord, I undertake to inform, my lord. I undertake to inform to, because he's not connected in the,
First, you should inform them.
please, my lord, phone is not connected. That is why I could not,
Then wait,
please.
wait, let the matter.
Serial number 36, my lord. Okay, for the respondent, my lord.
Yes,
Yes, for
please the other side.
other side is appellant.
For appellant in this case.
What do you want?
They are not deposit their amount, my lord, press for 2 weeks time, my lord.
My lord, I will deposit in a week's time, my lord, and the
The learner counsel for 36 says that learner counsel for the appellant states that the amount as directed shall be deposited within
week's time.
2 weeks. List on. Was there any order of the court?
My lord, there was an order, my lord, but within that time we could not deposit, my lord, and the,
It was an order to deposit by the court.
yes, my lord. 50.
Give the date.
17-3.
Mention, you just wait.
My lords, item 33, I appear for the appellant. My lords, I request 2 days of accommodation, my lord.
Please
Senior.
the other side. You for all the respondents? That the request for counsel for the appellant be notified. 33.
Serial number 27, my
3rd
lord.
of April.
I appear for the,
Minute, you have given the date, ma'am?
3rd of April.
Yes, 27.
I appear for the appellant, my lords, in MFA 4335 of 2020. I am requesting for an accommodation, my lords.
Please the other side.
Responded in the MFA number 4335 and for the
It
appellant.
appears in 27.1, that's a cross of.
Cross objections filed.
The request of counsel for the appellant in MFA 4335 of 2020, which request is not opposed, adjourned to.
7th of April.
Great.
But serial number 30, my lord,
Which number, ma'am?
serial number 30, I request,
30.
yes. I've informed the other side. There is, in fact, they informed me they would come.
At the request of counsel for the appellant for an adjournment by stating that she has informed the other side. Counsel for the other side. Adjourned to.
Interim order may be extended.
File your submissions.
Yes, ma'am. Interim order may be extended.
Interim order, if any, is extended.
17th of April.
Yes, Mr. Munjal.
Matter was mentioned on 20th, my lords. They have filed a FTP proceedings in a suit where the property was purchased by me in the name of my uncle.
Which number you are mentioning?
It's RFI, my lords, flesh matter, my lords.
Okay.
Any day next week, my lords.
No objections removed?
Objection in first matter removed, that the matter they say that will also be referred division bench. In the way I'll file a second set also.
No, then there are 2 appeals.
In one matter I have complied, my lord.
Comply in the other, then mention it. You complied today, mention it tomorrow, we will list it. Yes, who is, any other mentioning? No, take one. This you only want to you only produce the Lok Adalat report, no? Here now, you also in
Well,
the
it's
Lok
become-
Adalat, you have settled it.
Yes, it's been settled, and even though matter was disposed of as settled on 28/10/2024 by the trial court, my lord.
And we'll say that also in that. And based on the settlement before the Lok Adalat, the suit has also been disposed of.
Has been disposed of as settled based on the terms of settlement that's been agreed between the parties as per the settlement
The
deed
suit being form OS 1476 of 22
of 22, my
has
lord.
also been disposed of
Has been disposed of.
on 28/10/24.
24.
That's right.
That's right, my
Appeal
lord.
is dismissed as withdrawn.
Grateful, my lord.
Serial number 1. Serial number 1. Sri Vaidya Ravi.
For the
Appear
caveat
for appellant,
respondent,
lords. Appearing for appellant.
we've not
There's
received.
1 week of time to compile the office of election.
Where this, you had moved the court.
Yes, my lord.
Why? Just say this.
My lord, before moving the memo, it was registered between front of the register, my lord. So the file has been moved to the board office. So we didn't get time to compile the office of election. 1 week of.
Say that 2 weeks are granted to remove the office of it.
Office.
24-3. Serial number 2. Serial number 2, Shri Mohan Das Shetty, appellant in this matter.
I appear for the respondents.
I have a paper book. I will file it today today before the counter, my lordship.
In view of the
Paper
order of
book.
this honorable court, the appellant has to deposit 50% of the decree amount within 8 weeks. But they have not deposited till today.
No, my lordship, the small mistake has been done by the appellant, my lordship. He deposited the 3,21,000 with his personal account, my lordship. I enclosed that deposit with IA, my lordship. Deposit receipt with IA.
There are other objections, ma'am.
Yes, my lordship. Copy has been served.
Any other objections remaining?
Nothing, my lordship.
But
Paper book has to-
50% now, that you do it.
Yes, my lordship. For that only I filed the
Order
application for
dated
seeking
9/7.
extension of the interim order, my lordship. Due to his health issues and non-communication between the advocate and the appellant, he is not able to comply in proper way, my lordship. Interim order granted on 9/7/2024, my lordship.
Just say this, the counsel for the, we'll grant her time to deposit.
The remaining amount.
They have not deposited till today.
If he wants to deposit it, we'll give them time.
Right.
Okay? Then the counsel for the appellant, how much time you require?
1 month, my lordship, because appellant undergo for the heart surgery, my lordship. Due to for that reason, I'm seeking
The order is 9/7/2024.
What is the amount?
7,40,000, my lordship.
We will see either this will, let's be clear. It's immediate.
As per the order of this honorable court, 7,40,000 has to be come for the 50%, my lordship. 3,21,000 has been deposited already.
Have you got a copy of the application?
Today I
for
served, my
extension?
I got it.
Just say this is an application. 1/25 filed by the appellant. Seeking the. This is 1/24. 1/24. Seeking extension of order dated 9/7/24. Granted by this, passed by this court. For deposit of the 50% of the,
Decretal amount, my lordship.
50% of the decrease within 8 weeks. For the reasons stated in the affidavit accompanying the application. And the learned counsel for the respondent has no objection for this court extending the time. We extend the time by period of 4 weeks.
Much.
Okay. To deposit the amount as directed by this court. To deposit the 50% of the decretal amount as directed by this court on 9/7/24. Okay. Application disposed of. Fine, the appeal for hearing, the appeal on.
17,4.
The counsel for the appellant shall, just about that, counsel for the appellant shall also remove the office objections with regard to IA 1/25.
Much.
Do you, 1 minute, ma'am, do you pursue this vacation of stay application?
No,
You want to withdraw this?
I want,
We have extended it, you want to withdraw?
I will withdraw.
Dated 1/25 and the counsel for the respondent seeks to, just say this, in view of this, in view of the order passed on IA 1/24, then a counsel for the appellant, respondent seeks to withdraw IA 1/25, which is an application for vacation of stay. Dismiss as withdrawn.
Serial number 3, Shri Rajendra Kumar.
As of now, we will see.
Lord, in this case, my lord, I appear for appellant.
Serial number 3.
Yes.
My lord, I appear for appellant, my lord, supposed to file an affidavit giving the details, my lord.
Who is the other side?
Lord, other side, my lord, is state government. My lord, I am,
Where is the gentleman? Mr. Raghav Basil.
he has been served and my lord, he is unrepresented. In fact, my lord, the affidavit has been sent, my lord, I am with the details. It is said to receive, my lord. I am filing a memo, my lord, giving the details of this.
Have we issued on these applications notice?
Lord,
Issued?
Lord, it was dismissed for non-prosecution, my lord. It was dismissed for non-prosecution, my lord, on the earlier.
That we have to restore, we have to notify him, now the other side. Was he appearing in these proceedings?
No, my lord, he has not appeared even in the writ appeal. No, my lord.
Never appeared.
No, my lord. Yes, sir, even in writ appeal, main appeal, my lord, the notice was issued. He did not represent, my lord.
When did he last appear?
No, he did not appear, my lord, in this writ appeal.
At all?
Yes, yes.
Just say this, you appear for the respondent?
State government, my lord, is a formal party.
This, these three are applications. This would be IA number 2 of 24. Where is your affidavit?
Lord, I have. It was filed on 17th December.
Just say 2 of 24, this is an application seeking recall of order dated 12/22, whereby the 16/12/24, whereby the appeal was dismissed for non-prosecution. For the reasons stated in the, we find that we have been informed that the respondent number 1 is not appearing in these proceedings. Neither was he present when before the court on 16/12/24, when the appeal was dismissed for non-prosecution. Full stop. The learner counsel for the respondent number 1, 2 has no objection for the restoration of the appeal for the reasons stated in the affidavit accompanying the application, comma, the order dated 16/12/24 is recalled, the appeal is restored to its original position. This is the appeal for hearing and application disposed of.
(15-4).
That's it.
Serial number 4, Shri Vishnu Hegde.
My lord, I undertake to appear for respondents 1 to 5, my lord.
You appear for 5 also?
Yes, for 5 also.
In 6 you have to.
Yes, my lord. In the meanwhile, there was an order for deposit of the amount, my lord. The 50% of the decretal amount. I have deposited 7,50,000 and also filed the application for extension of
How much is the balance?
The balance, my lord, it is about 46 lakhs, my.
What is the use of depositing 7 lakhs?
I agree because he has undergone for trunk surgery, my lord.
The order passed for deposit.
The 3/12, my lord, 24.
3/12?
24.
When did you, how much time was granted to you?
I agreed, my lord. The
How much
6 weeks time was granted.
Did you file this application for extension?
Yes, my lord.
When did you file?
Yesterday, my lord.
How much time you require?
4 weeks, my lord.
4 weeks?
Yes, my lord.
Just show us the filing. Just say this. So and so appears for the respondent states that she shall appear for respondent 1 to 5.
Yes, 1 to 5.
We will stop it that way. So notice to respondent number 5 is dispensed with. The respondent number 6, let notice be issued to respondent number 6. Returnable on. Then say that when a counsel for the appellant states that he has filed an application before in the registry. Is it there, man? Of time.
Yesterday, my lord.
Or
One copy.
of time to pay the further amount. To pay the complete amount in terms of order dated 3/12/2024. For the reasons stated in the affidavit. We find from the affidavit in support of the application. A sum of rupees 7,50,000 has been deposited by the appellant. Suffice to state The balance amount shall be deposited. Suffice to state, comma, as paid by the counsel for the appellant. Comma, and also noting the prayer in the application. We grant 4 weeks further time to the appellant to deposit the comply with the order dated 3/12/24 by depositing the balance of the amount in terms of the said order within 4 weeks. Full stop. On such deposit, further action shall be taken by the registry in terms of order dated 3/12/24. Application disposed of. This on
22-4, serial number 5, Sri Mayana Gowda.
Applying for the applying, my lord. Needful done, my lord. Needful done, my lord.
or needful.
Process taken. Respondent.
Say that notice be issued to respondent returnable on.
25-4, serial number 6. Lordship.
Issue. Ma'am, we'll do one thing. Just say this is in filed by the appellants. Filed by the appellant, only single appellant.
It's a defendant's appeal, my lord. A memo for withdrawal filed by the appellants. Appellants.
In fact, that the parties have settled the dispute before the executing court.
Please, my lord. Commercial
The
exit.
appellant wishes to withdraw the appeal. So far as your refund for court fee is concerned, you need to just only check it. We will make it part of our order also.
Please, my lord, may I make submission, my lord?
Yeah.
As per section 16 of the Court Fee Act, my lord, I am entitled for the full refund of the court fee.
There is an amendment. Is there any amendment? Is there any amendment which has come, which says?
Just go through that, there is an amendment in the court fee.
I will go through it.
Yes. What judgment said?
The issue is only between 100 and 75%. Between 100% or the 75%.
Yes, my lord. I do agree, my lord.
We just need to check up that and then pass order for the refund of the court.
Please, my lord.
Okay, we will make it part of the order. We just want to check up that. Okay?
Yes.
Principally, we have allowed you to withdraw on principally insofar the court fee is concerned, should be paid. How much is the issue? That we will clarify and then make it.
Understood, my lord. Very well.
Just check. There is some amendment which has come which says 75%. Have you checked up that?
I have checked section 16 of the Central Court Fee Act 1870. And I have also got the citation of this honorable court. Recent amendment, I'll check. my lord.
66. Just to go through that.
My lord, pardon.
Just have a look there.
Please.
Okay? Next.
Serial number 7.
Appealing for the appellants, my lord. My lord,
Nothing for
I
the
am not
record.
pressing the A number 1 of 2024, my lord. In the meantime, respondent number 1 to 4 have sold the property to proposed respondent number 5 and 6. They have also made the application. For that, it may be allowed. Yeah, we got no objections.
For what?
To bring the respondent number 5 and 6 as an additional respondent, since they are the bona fide purchaser of the suit schedule property.
You are for the appellant.
Yes, my lord.
You are not pressing IA on that.
I number 1 of 24, I am not pressing.
Now 24 is for what?
For impleading filed by me, and they have also come up with the impleading application.
Their application is not listed.
Yes, my lord, they have not.
Listed?
On office objection. Is on office objection.
Will
Okay,
come.
let it be listed there.
Yes,
But you want to withdraw this?
my lord, I want to withdraw the I number 1 of 24, my lord. My application is concerned, I am withdrawing.
Then the counsel for the appellant states as the respondent. You appear for whom?
Respondent number 3. And proposed applicants.
Who appears for 1 and 2?
1 to 4 only, they are only appearing, my lord. 1 to 4 also, they are appearing.
You 1 to 4, you are appearing?
Yes, my lord.
Appearing for respondents 1 to 4 states that she has filed an application for impleadment of,
Respondent number 5 and 6.
impleadment of.
Proposed.
Proposed respondent.
Impleadment of, who are the names? What are the names?
Srimati Chandrakala Umesh and Umesh HR.
Srimati Chandrakala,
Umesh.
Umesh and
HR.
Umesh HR as respondents 5 and 6. The said application is not listed. And as such wishes to withdraw the application. We find that the application filed by respondents 1 to 4 is not listed. Then the counsel to get it listed on the next date of hearing.
My lord, short date may be given because matter has been settled between the parties. Now we will file the compromise petition.
Let them come first.
Short date may be.
5 and 6, let them go. You get it
We
listed.
will comply the office objection during the course of the day, madam.
So when do you want? Tell us the date.
Tomorrow, my lord.
Tomorrow or day after tomorrow.
Sure, you will get it.
Yes,
Just
my lord.
put it in 5th or 6th. We will have it on 5th or 6th.
Yes. my lord. 5th, my lord.
No, he filed application. I'm seeing. He said he filed application.
ನಿಮ್ದ್ರ ಮೇಲೆ objection ಇದೆ.
Service.
So then once paper objections in this.
Faintly overturned.
No problem. She also filed it.
After the objection otherwise.
First application.
Get it listed on the next date.
5th, my lord, next month.
Just give it.
5.
Obliged.
Serial number 8. Serial number 8. Shri Prakash
In the
and-
course of the day, I will comply the office objections.
Notice be issued to the respondent number 1. By removing the office objection.
Yes.
Some I think not requisite court fee has not been filed, process fee has not been.
That I will pay today.
1 and 2, respondent number 1 and 2.
Yes.
Give it.
21-4.
Great.
Serial number 9. Serial number 9, Shri Venugopal.
For appellants. They say that when counsel for the appellant has filed a memo for withdrawal.
Yes, my lord. And also direct the office to return of court fee, my lord. Yes, the matter is settled before the execution court, my lord. Joint execution court, my lord. Joint memo and order sheet has been filed, my lord.
Where is the memo?
My lord, page number 1, my lord.
Which means as under. We will check up, how much.
75%. 75%.
25%.
75%.
Section 66 of clause C, my lord, it says 75%.
Correct,
Prior to hearing, commencement of the hearing.
correct, correct.
Yes, ma'am.
But any hearing.
But is there any latest judgment is there? We need to check that on the full refund of court.
We'll say 75%.
Please,
In your case,
Please,
please.
in your case,
please, madam.
75%. Yes, sir. 55% of the court will deposit.
Serial number 10.
Dismissal is withdrawn.
Appearing for respondents.
Appearing for the appellant, my lords. Lords, for the appellant, my lords was pleased to hear this matter yesterday. This is as against the rejection of the Section 8 application under the Arbitration Act.
What about the court fee paid?
Court fees paid by.
Court fees
the
paid.
lower court. By the plaintiff, my lords. I'm for the defendants.
No, but there was some objection on this. You can see yesterday.
Only some. Yes, we are in praise, they have to mention.
Sufficient. Receipts of court is sufficient. Yes, now what are your instructions?
My lords, if I may submit, yesterday an order sheet was produced by the learned counsel for the appellants, the respondents. My lord, in that, if I may take you to page number 9, my lords, in the order sheet. Order sheets. Page number 9, my lord, it is clear that paper publication is taken on 28/10/2022, my lords. Thereafter, my lords, it is as per order 5 rule 20, it is as effective as serving the defendant personally. So the date for which written statement has to be filed has to be calculated from that day onwards, my lord. Thereafter, my lords, in page number 19 of the order sheet and 20, the court, without authority, has extended time to file written statement after the expiry of 120 days. If I may rely upon a judgment, my lords.
Were they served through paper publication?
Yes, my lords. It was substituted service, deemed service.
Now, that was an earlier date.
Earlier date. So, my lords, as per this judgment,
They extended the time to file return.
paragraph 8,
What is the judgment?
paragraph 8, my lords. The last portion in paragraph 8. Lordships have got it, my lord? A perusal of these provisions, which is order 5, 1 sub rule 1 and order 8 rule 1, it would show that ordinarily a written statement is to be filed within a period of 30 days. However, grace period of a further 90 days is granted, which the court may employ for
This proposition we know.
My lord, yes, my lord. The last line says, court has no further power to extend the time beyond this. So the court extending the time in the year 2023, after setting aside the ex parte decree, is without authority, my lords. Hence, Section 8 application is barred by time.
See, the impression we got yesterday was this. That you were ex parte, you filed an application for setting aside, and your right to file written statement would only arise after that application is decided.
Sir, please.
To the extent of ex parte, surely it would be, you would not be allowed. But once restored, the time starts running. And it would end only in December. And you file it before that.
May I submit, my lord?
Yes.
My lord, that part of the order is not challenged. There's only a single order. My lord, the challenge,
Yeah, what is being urged is,
I bow down to that. my lord.
if 120 days have expired, even the court could not have extended.
My lord,
We are putting it to you now.
yes, yes.
When the order was passed, maybe rightly or wrongly, by the trial court, whether 120 days have expired from the date of knowledge on the suit. Your date of knowledge on the suit. Because your right to file written statement starts running from the date of,
I bow down.
summons are served on
Yes.
you. Now, in this case, it's the publication of the notice in the newspaper. That would be the date which will take it.
My lord, to that extent, if my lord is pleased to see ink page 52 to the, my lord, where we've specifically stated in paragraph 2, our contention has been considered in support of these two applications. Second defendant so and so has sworn to an affidavit stating that the plaintiff has filed an instant suit seeking declaration against the defendant and is liable to pay rent calculated at the rate of rupees 11 per square feet with other reliefs such as payment of arrears. No notice was validly served on the authorized officer of the second and third defendant company and the firm, and they have a good case. Even though, my lord, this is our contention, and we have not filed a statement of defense. So far as section 8 is concerned, my lord, that if we have not filed our statement of defense, even if my learned friend's contention is considered and accepted by my lords, this order, including the extent of the order, is the order. The operative part of the order gives me two reliefs. One at ink page 55. One is it says that the ex parte order is set aside. The consequential is to permit me to file the written statement. Now, this order, my lord, which is passed over a year back, is not challenged by them. Now, the court has obviously a finding. My learned friend would have placed the very same submission before the trial court. The trial court has rejected his submission. If his submission was accepted, the trial court would have simply said that as far as ex parte is concerned, you are no longer ex parte, but you are not entitled to written statement because of substituted service and the proposition of law laid down by my learned friend based on the Supreme Court judgment.
When was the paper publication done?
My lord, that was on 28/10/2022.
Okay. When were they proceeded the ex parte?
Yes.
Okay. And when did you file application for restoration for setting aside?
3/7/23. 3/7/23.
23?
Yes.
Okay.
The application is allowed on 4/8/23.
Including my affidavit, my lord, ink page 43, relevant part is at ink page 46, paragraph 5 and 6.
Come to that.
Yes.
And written statement time granted.
Yes.
That's on
4/8/23.
Yes.
And once again on 26/9/23 and once again on 7/10/23.
3 times it was granted.
Yes.
When did you file section 8?
On the next.
7/10/2000.
7/10/23.
Okay. Now, you have these facts with you?
Yes, ma'am.
Should have.
Yes.
28/10/22 is the publication.
Please.
The time starts running.
My lord, I have specifically taken a contention that I have no knowledge of the paper publication.
Make any difference. In law, we will look into it. We will say so. We will take it. You have the knowledge.
My lord, an order, I most respectfully, my lord, even if my learned friend is right in his submission, I'm submitting for my lords, the relief which was granted, my lord is pleased to see, that order has not been interfered with by any court. And nor is it under challenge. If My lord, my learned friend was aggrieved by that part of the order. They would have rightly filed an application or a writ saying that that order is.
Did you actually file the written statement?
My lord, that's what I want to say to my lord. What we did is immediately we filed the application under section 8.
When did you file immediately?
My lord, on
10/23.
7/10/23, the order was passed on 13/9/23.
We are saying.
Yes.
It in this perspective.
Yes.
28/10/22 publication.
Yes.
Time starts running. 120 days. You did not appear on 28/11. You were proceeded ex parte.
My lord, then most respectfully, my lord, that two aspects are there. What fell for my lords is, when did I file my written statement? After filing the section 8 application and after it being rejected by the trial court, I filed an application to take my written statement on record. The reason is that if the court has no jurisdiction under section 8, the question of me filing the written statement would not arise.
We say nothing on that. We are only concerned with the section 8 application having been.
Yes. My lord, section 8, if I may be permitted to read section 8 also, my lord, of the Arbitration Act. It says, my lord, a judicial authority, subsection 1, before which an action is brought in a matter, which is a subject matter of agreement, arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement. Therefore, my lord, if I filed my written statement, which is my statement of defense, that is one. Even I'm submitting this for my lords.
To file written statement within 120 days. Now, what is being advanced is.
Yes.
Is this. They have not filed the written statement within 120 days.
Yes.
And this application has come after the expiry of those 120 days. Hence, this application cannot be allowed, section 8, and that's the reasoning given by the trial court judge. You're getting the point? See, it should be within 120 days, you must file an application. That the intent of the order is this, you should file the application within 120 days without filing your written statement, or you can file it simultaneously without prejudice.
My lord, we have filed it within 120 days of the order of setting aside ex parte.
What we are putting it to you. We want to know your stand on this. These are the dates which we are giving. Kindly listen to us for a minute.
Yes, my lord.
28/10/2022 is the publication.
You have the copy of the publication? Do you have a copy of the publication?
Didn't get it. I can place it on.
My lord, I don't have a copy of that publication.
The order sheet itself, it's.
No, I just want to see because you were saying that both.
Recorded in the order sheet.
You
It
have
is-
order sheet with you.
My lord, I think only one has been placed through
Order
paper.
sheet they have filed yesterday, my lord. Order sheet they have filed yesterday.
My lord is pleased to see the order sheet at ink page 10, my lord, what my learned friend placed. Sorry, first paper, page 9. The order sheet, which has been filed now, my lord. You can copy. Yeah. Yes. My lord is pleased to see 39/22, my lord, ink page 8. The counsel for the plaintiff present and file memo for furnishing fresh address to defendant number 2 and sought for issuance of summons and new addresses. Then 11/10/22, counsel for the plaintiff takes present and praised time to take steps 18/10/22. 18/10/22, the counsel for the plaintiff present. And my lord is pleased to see on the left side, there is no refusal of the notice or service being served. Please see, my lord, that substituted service will arise only under 2 circumstances.
We don't know.
No, my lord, if my learned friend is relying on this, I'll just take my lord further. There is no refusal. The counsel for the plaintiff present filed an application under Order 5 Rule 20 of CPC, seeking publication against the defendants 1, 3, and 4. We are appearing for 2 also. It's only 1, 3, and 4 by paper publication along with draft publication. We are for 2 also, my lord. Peruse the application, the same is allowed. Issue summons through paper publication to defendants 1, 3, and 4 to carry out the paper publication on or before 27/10/22, and for the appearance and reissue of summons to defendant number 2 through court and RPAD if PF is paid. The next order, my lord, 8/11/22. The counsel for the plaintiff present and file memo along with newspaper publication for carrying out the against defendants 1, 3, and 4. The same is taken on record. Defendant 1, 3, and 4 called out. None appeared and placed them ex parte. So it's 1, 3, and 4. We are for 2. Summons to defendant number 2 is duly served. Called out, none appeared, placed ex parte. Now, defendant number 2 has filed the application also under Section 8.
When were you served?
My lord, according to the court, it's 28/11/22. That order is what is set aside. 28/11/22, there was no order for paper publication as against defendant number 2.
You're asking defendant number 2 was served on 28/11/22.
22.
Now, your right to file written statement starts running on that day.
My lord, that 20. Yes,
2 aspects, right to file written statement and proceeded ex parte.
please.
What is there is you were proceeded ex parte. When were you proceeded ex parte?
28/11/22.
On the same day?
Please, my lord.
Okay.
Yes,
Yes. Your time to file 120 days starts running.
please,
You did not appear, you were proceeded ex parte.
please.
And you filed the application for setting aside on 3/7/23.
3/7/23.
Much after this 120 days had expired.
Please.
Okay.
Yes.
Now when you are proceeded ex parte or when restoration takes place, when it is set aside, it would be from the position or the status of the proceedings, which is existing on that particular day when it was set aside. By the time your right to file written statement was forfeited, it goes. It is the point. So you will not get extension of filing a written statement, but you will be brought on record for the purpose of these proceedings. I
Most-
appreciate it.
Yes, I understand what's in my lord's mind. In fact, I came across one judgment of the Madras High Court, which said that the moment an order is passed setting aside a person ex parte, he or she would revert to the position they were on that date. Therefore, the clock will now go back to 27/11/22. Because, my lord, if the clock doesn't go back, I would most respectfully submit 2 consequences of not filing a written statement. One is my defense is not on record. Second is I can't lead evidence because there are no pleadings. Third is my cross-examination, my lord, will be superficial because I will only be questioning the plaintiff on technical aspects because my defense is not there. Then, my lord, if my learned friend's submission is accepted, it would amount to that order of me being placed ex parte being set aside is of no consequence.
Put it to you. You file your, see, important is the delay which you had, delay that occurred in filing the application for setting aside ex parte. That was filed on 3/7/23. Mind it. Your right to file written statement, even if you had appeared before the trial court, it would have expired in 1/12, in February 23. Kindly appreciate. You getting the point?
Yes.
Even if you had appeared, your right to file written statement would have expired on 28/2/23. But you file the application for restoration or setting aside ex parte on 3/7/23. By the time that 120 days had expired. So even if it is ex parte set aside, it will not endure to your benefit that the time gets extended for 120 days. It would not happen. I hope.
Yes, I understand what's, my lord, in fact, I may be given some time to come back to my lord on this. The reason is, I'm giving on the time, my lord, what my learned friend said. There was a case, my lord, which was before the Honorable Supreme Court, wherein a person files an application under Order 7 Rule 11 in a commercial proceeding. And the pendency of the application and the decision of the court concerning that application was considered as to whether during that period, non-filing of a written statement before the commercial court would mean that I'm giving up my right. It was presided by Honorable Justice Maheshwari as he was there. So that may not be just in zeros and ones.
What you are advancing is this. Without filing a written statement, you filed 711.
Yes,
The 711 took time for a decision.
yes,
By the time 120 days expire,
yes,
you
yes.
will not get any benefit. Let's be clear. Without prejudice, you will file your written statement. Once starts running, it will continue to run.
There's one,
That law is settled.
sorry, it was section 10 application. And orders, I'll just, please give me a day's time and I'll place that judgment. And I've got one judgment of the Madras High Court, which basically, it's only persuasive to my lords, to say that, which it will be contrary to what my learned friend is saying, to say that once I'm placed, the ex parte application is allowed, I'm placed back to the status as I was then. And that my lord is saying that I'll be placed back as on 28/11/22. And even if I'm placed then, that time has lapsed. I would only say that, my lord, because that time period, and most importantly, since there's no challenge, and I want to also canvass this submission, which I'll place some authority, that even if an order, my lord, is passed without jurisdiction, an order is passed without jurisdiction. For a moment, if my learned friend's submission is that the part with reference to a written statement is passed without jurisdiction, my lord, my submission would be that even if an order is passed without jurisdiction, or it's not without jurisdiction, the court has the jurisdiction to pass an order. If an order is passed ultra vires or contrary to the statute, my submission would be that order will be valid till such time it is set aside. I'll just place two authority.
Contrary to this order of the Supreme Court.
My lord, I'll just, please give me a day's time, my lord.
Sanctity of 120 days gets lost.
My lord, but if my lord is pleased to see, when we,
Very well.
yes,
I hope, we hope that.
my lord is clear. There's no ambiguity in what's falling in my lord's mind.
Just think over.
Yes, yes, that's what.
If you were to appear.
Yes,
Normal course.
Yes.
And this is defendant number 2.
yes,
Your 120 days would expire in February. Because 28/11/22.
yes.
That was the date when you were served. What was the date when you were served?
My lord, according to the records, it shows that I was served on 28/11/22.
Let's take that date. Maybe you must have been served earlier than that. That's the date of hearing before the court.
What it says, my lord, as I read the order of setting aside ex parte, my lord, it's an interesting question in the fact that what would happen if an ex parte order is allowed in a commercial suit, what would be the benefit of a person? In effect, what my learned friend is saying, that I would get no benefit. That may not be completely right in my most respectful submission.
Yes.
I'll just examine that, my lord. My lord, one more aspect. My lord, I request 2 days' time for that. My lord, yesterday, my lord was orally pleased to direct parties not to precipitate the matter. My lord is pleased to direct that we both of us will take an adjournment. And what I understand is the plaintiff is insisting that we cross-examine them today. I request, my lord, that
It was for cross-examination today.
today,
Fine.
let it be taken for Monday, my lord.
Said to take adjournment.
Yes, but they have, I mean, with all respect to my learned friend, what my instructions are that they have said that you have to cross-examine today.
Take an adjournment.
My lord, the plaintiff is also not available in station, so
Who?
the plaintiff, my lord, so
in any
that
case, you
cross-examination will, yes, my lord, that will.
He says seeking an adjournment.
Yes, I mean, they are saying something to the contrary in the trial court. My learned friend may not be aware.
So then we will make it part of our order. If you are saying take an adjournment, but we will having it, when do you want?
Monday, Tuesday, my lord.
Well, just say that at the request of counsel. We'll have it on 5th February. Today, is it listed or taken?
Today, my lord, today. It's passed over today morning.
States that as the, what was the execution?
No,
the suit.
cross-examination.
The suit which is pending, consideration before the trial court, the party shall seek an adjournment to a date beyond the date fixed by this court in this appeal.
Grateful.
Okay? We are not saying, don't wait for the order, just convey to the.
I'm sure my learned friend will convey it. Grateful.
Number 11.
Appellants.
Yes, Mr. Patel.
Please. First, may kindly take annexure H, page 367. Kindly come to para 3 in the middle portion at 371.
What are these proceedings, Mr. Patel? What was this petition?
This was initially, your Lordship may kindly recollect, I was arraigned as a accused number 16 in the proceedings in predicated offense under annexure C. Ultimately, they dropped proceedings against me saying material is not, there is no material to proceed that is available at annexure C. After that, again, an FIR was filed against the appellant.
When was the FIR filed?
This FIR, I'll give the date. 26/2/2021. In respect of the same incident, this FIR was filed. In this, they included offense under, kindly go to page 371, last 2 lines. They had sought to prosecute for offense under the Cooperative Societies Act under section 109 and included offenses punishable under section 120B, 168, 200, 403, 405, 409, 418, 419, 420, 424, 425, 427, 467, 468, and 474, read with section 34 IPC. This was registered, they registered an FIR that was challenged by me. In that, my lord, ultimately the court passed the order quashing the proceedings. Page 400. In the case on hand, it is held, while discussing point number 1, that FIR 16 of 2021 could not have been registered for offenses under IPC. There remains only the offenses under the Act, that is Cooperative Societies Act, in respect of which competent authority, authorized authority only can initiate criminal action. Therefore, this writ petition deserves to be allowed. Ordered accordingly, FIR so and so registered by respondent number 5, police station is quashed. But this order does not come in the way of initiating fresh action against the petitioner by filing complaint by competent or authorized authorities for the offences under the Karnataka Cooperative Societies Act. Under Karnataka Cooperative Societies Act, for contravention of bylaw or statutory provisions, certain offences are provided. I preferred an appeal in respect of those that sanction under Annexure J. My appeal is allowed, setting aside the granting of sanction and initiating proceedings for offences under Cooperative Societies Act. The translation is available at page 404, operative portion at 407. Thus, the second attempt to register FIR, including certain offences which are predicate offence or schedule offence, was quashed. It is after this they sought permission under section 173(8) in the earlier case and again started investigation, continued investigation.
After that 26, after that new FIR, was there a new FIR, fresh FIR?
No, no. In the earlier FIR where charge sheet was not filed against me, in that they made an application under section 173(8) for permission to continue the investigation against the petitioner against whom they had not filed charge sheet.
In crime number 325 of 2014.
Please. That is at Annexure G.
There was no impediment to carry out the fresh investigation.
They, under 173(8), they said they wanted permission. They have a right. Whether it is rightly done, wrongly done is another aspect. They have power to do it. That was done. Kindly go to page 273. Annexure G, in that page 273. Now, the number is changed to accused number 15. Earlier, it was 16. Now it is changed to accused number 15. 273 bottom, your lordships get it. Particulars of the accused charge so and so. Accused number 15, name R.M. Manjunatha Gowda. In that, page 274, Roman 12.
Yes.
Offences are section 409, 202, read with section 36 IPC. These offences are not predicate offense. They are not scheduled offense.
Did you file your objections or counter affidavit, Mr. Kamath, before the learner single judge?
Yes, we did.
We have filed.
Yes.
Illa, file madilla.
No, I'm
That-
sorry.
In fact, that is one of the objections that I wanted
I
to
think
take up.
we filed a synopsis.
You have filed. There is something on your side in, something in writing there.
Yes, we filed a synopsis.
(274), the offences, and your lordship may kindly notice that this additional charge sheet which is filed, cognizance is yet to be taken. It is this additional charge sheet which was challenged by me in WP 22989 of 2023. That writ petition is dismissed in the present order. Of course, though contained in the common this thing, by a separate order that is dismissed, saying
Let's see that.
Please.
That order.
your lordships get it at in the impugned order, typed page 41, ink page 57.
What was the repetition number?
22989 of 2023.
Is it 22 or 989?
22989.
Where is the dismissal order? Where is the dismissal part of this?
Please, my lords.
Page 57.
No, it's at page 63. Last line comes in page 64. Page 63 bottom. Of course, I had raised the contention that petitioner is not a public servant, etc. That all it is being said is all those stages will come at a stage where they can raise those grounds. And
Your case is still that it is not a predicated offense?
it is not a predicated offense, and even cognizance of this additional charge sheet is not, additional charge is also not taken.
That's right. But in
That's-
any case, but that is on those offenses under 409 and.
Yes, ma'am. They are not schedule offense. They are not schedule offense. Ultimately, the so-called synopsis that was filed was something that was given to court as if it's a matter which we are not entitled to know about.
What has been given?
This synopsis. Therefore, that's not part of the writ appeal.
But what have you filed, Mr. Kama?
Lord, I'll get it, Lord. We filed as, we captured the essence of our submissions before the court.
You have
Yes,
not given to them?
it was given to the others.
May not correct, but anyway, this.
Well, let's not work very well.
Yes, yes, my lord. Your lordship may kindly see.
But do you have a copy now?
No, my lord, we don't have a copy now. Now, my lord, with this background that presently I was arraigned as an accused in a predicate offense case, and they found, initially they found there is no material to prosecute. Now they have filed a charge sheet for offenses other than schedule offense. I am an accused in a case where initially it was for some of the offense, schedule offense, but ultimately I am now because there is no schedule offense case against the
Now,
appellant.
The summons which you have challenged
Yes,
was in which writ petition?
that is in WP 22780 of 2023.
Now, let's see.
The summons, your lordship may kindly peruse. That is annexure A at page 91. ECIR number is quoted. It is served by hand. It is dated 6/10/2023. I so and so, making an investigation under the provisions of Prevention of Money Laundering Act so and so. And whereas I consider attendance of RM Manjunath Gowda necessary in connection with the said investigation. Now therefore, in exercise of the powers conferred upon me under subsection 2 and subsection 3 of section 50 of the said act, I require said RM Manjunath Gowda to appear before me in person at my office on 9/10/2023. Schedule: original Aadhaar card, passport size photo, and passport. 2. Details of all immobile properties held. 3. Details of all bank accounts and movable properties held in your name and in the name of your family members. Copies of the ITRs filed by you from the last 15 years along with annexures. Now your lordship may kindly also see what of these are two summons issued to others in the same case. One is issued to HC Asha, wife of Manjunath Gowda.
They were also summons.
Yes, summons. Kindly see. To depose your statement. Of course, she was not there in the schedule offense, even as a this thing. To depose your statement. That is also issued on 6/10. Then your lordship may kindly see the other one. It is addressed to NG Nagabhushana. Again, to depose statement. He was an accused in the same schedule offense case as accused number, originally as accused number 15. For him and others, it is to depose statement. To say that we want to record their statement, etc. The summons issue, there is no case registered or not, is not being divulged to the court. Whether it is registered against me or this thing, because they have not filed anything in writing. This summons is not a summons issued for recording a statement or collecting of information. On the other hand, they have this indicates the case is, whether it is CRPC is applicable or not, a case under the PMLA Act is registered against the present appellant.
How do we get that?
That is because they want the property particulars of the appellant. They want the bank account particulars of the appellant. if I were not to be a person to be investigated with regard to the money laundering offense, the summons would have been a simple summons saying, we want to record your statement. We want to know something about some information.
Then what will follow?
What will follow is, I'm following it with the specific wording in Vijay Chaudhary case, saying at paragraph 283.
One thing, Mr. Patil, till such time there is a predicated offense, you are part of predicated offense or a scheduled offense. They can't proceed.
That is what I want to bring to your lordship's notice.
Then you just hear us. So then, when you are not part of the scheduled offense, whatever summons have been issued would be, the value would be the same that they want to maybe possibly record your statements. That's all, nothing more than that.
That even there should be, there will be a difficulty because that is not what they have put in writing.
Pardon?
That is not something which they have divulged or put in writing to the court, even now. And even now, that statement is in black and white is not being made.
But we will see whatever is on record, Mr. Patil. And it's your case also, and it is, and surely it is not their case also that you are part of the predicated offense. It is not your case also?
At this stage, now we are only investigating.
That's all.
We want to find the money trail. We want to find out the trail of money.
They, as of today, when they have issued you summons, it's only to record your statement possibly.
Yes.
There is nothing predicated offense against you.
It may not be available to do that. Your lordship may, I will take to the other things. Your lordship may kindly go to para 283 in Vijay Madan Raj Chaudhary case. That might be page 129.
283.
Please, my lord. Of course, from 281 it starts, but anyway, at present, I will just point out this. Even though 2002 Act is a complete code in itself, it is only in respect of matters connected with offense of money laundering. And for that, existence of proceeds of crime within the meaning of section 21U of the Act is quintessential. Absent existence of proceeds of crime, as aforesaid, authorities under the 2002 Act cannot step in or initiate any prosecution. Cannot step in. Issuing a summons to a total third party asking for information is something, yes, they can say we are trying to find out something, we want to collect information to a third party, as it was done in that Madras case, wherein summons was issued to the district collectors asking for records and information with regard to mining cases, which according to them was a predicate offense case. There it was issued to a total third party. Here it is issued to a person who is an accused in a case in which, as far as he is concerned, though initially he was sought to be brought in the case of schedule offense, later they have filed charge sheet only in respect of this thing. Actually, this discussion would be complete in para 251 to 253 and 281 to 283. If your lordships permit, my lord, I would like to Please, your lordship may kindly take para 251. 250 to 253.
But Teles, are you advancing a plea? They can't even call a third person to record a statement.
Third person they can call. As far as the present this thing is, indication is whether they divulge or not divulge. Indication is you are one of the
How would you get that?
without,
There is an assumption.
because I withhold the information, it is not necessary that court will not be able to infer certain things.
See, then, no, it's only this, Mr. Patil, that's what we are asking you. Though you are not part of the predicated offense, should be-
Please.
Can't they, or they don't have the powers under the act to call a person to record his statement? Is it-
Your lordship make a visual, your lordship may visualize three situations. One is, there is a predicate offense case in which X is not one of the accused. Totally, he is not one of the accused. But they have certain information or the material at their command, which according to them shows that he is at a stage of money laundering, that is after the schedule offense, he has come in one of the process under section 3 of the PMLA Act, a total third party who is not accused there. Yes, they can summon him, they can investigate, they can even register a case against him. There shall be, that is, of course, subject to what material they have. Then there is another situation where a person is accused in a case where there is predicate offense. In that, apart from predicate offense, they want to proceed under PMLA Act. They have material to show that apart from predicate offense, embezzlement, etc., he has further involved himself in money laundering in one or the other manner under section 3 of PMLA Act. Third is the case where I am in. Here, I am accused in a case of schedule offense of, let us say, embezzlement, which is a schedule offense. After investigation, they don't file charge sheet against me. Thereafter, an effort was made again to file an FIR and charge sheet for schedule offense. That was also quashed. Even after that, after 2 years, they again investigate, further investigation, permission is taken, further investigation is done. That again, they find nothing to say to involve me in the schedule offense. Therefore, in respect of a person against whom schedule offense initially is given up, second time, it is quashed by the court. Third time, after investigation, they don't find anything to include me in the schedule offense. In respect of such a person, there is no question of their saying, we are only making investigation, making this thing, etc., because they are proceeding against me as indicated in the summons itself. They want my property particulars. They want my income tax returns. They want the bank account particulars of myself and my family members. There is no gainsaying in saying that we are trying to get information. They have registered a case against me. That is not something which is permissible. I'll just...
What follows? What follows still?
That what follows is at the stage of summons has said a 3-judge promotional assumption of offense under the PMLA Act, etc. If that is read together, I would say, even at the stage of this summons also,
But tell us the basis for them to proceed against you should be your part of the schedule offense, which according to you, as on date, there is nothing. Okay, if that shows presumption in law can be drawn that they can't proceed under the provisions. That's right. The presumption. That are they precluded if at all they want. Is that the case? No, it's not the case there. The power is there or not, that's the more.
in respect of a person in a position like the present appellant, I would say, my lord, they cannot step in at all. They may, on getting the information by anybody and everybody, they may register a case.
Assume for a moment, there is a person, X person who is there, part of the predicated offense. They can proceed against him, but they want this gentleman to be there to make inquiries or to settle, to record statement. They can't do it.
That could have been, but they have, for a moment, either by slip of tongue or otherwise, issued a summons asking me to produce my property document, my relatives' property documents, my bank account, anybody's bank account in my family, my ITR returns for last 15 years with all the annexures. This is not a summons issued to find out something about anybody, etc. Your Lordship may kindly see page 250.
The end, my lord, I would need 5 minutes.
Yeah. Yes.
Para 250, my lord, I wanted to take your Lordship to 250.
Yes, let's read this.
That would be page 100, printed page 100, para
250 to 253, no?
250 to 253, 281 to 283.
Let's read it.
Please. The other relevant definition is proceeds of crime. In section 21U of 2002 Act, under the Act, prior to amendment with a Finance Act so and so, took within its sweep any property mentioned in 215 of the Act derived or obtained directly or indirectly by any person as a result of criminal activity relating to the schedule offense. Schedule offense mentioned in section 21Y read with schedule of the Act, or the value of any such property. With a Finance Act 2015, it further included such property being proceeds of crime which is taken or held outside the country, then the property equivalent in value held within the country, and by further amendment by Act 13 of 2018, it also added property which is abroad. By further amendment, Finance Act 2019, explanation has been added, which is obviously an amendment. That is evident from the plain language inserted in the explanation itself. The fact that it also includes any property which may directly or indirectly be derived as a result of any criminal activity relatable to provision, in that the word relating to, associated with, has to do with, used in the main provision is a present participate word relate, and the word relatable is only an adjective. The thrust of the original provision itself is to indicate that any property is derived or obtained directly or indirectly schedule offense. The same may be regarded as proceeds of crime. In other words, property in whatever form mentioned in 215 is or can be linked to criminal activity relating to or relatable to scheduled offense must be regarded as proceeds of crime for the purpose of 2002 Act. It must follow that the explanation inserted in 2019 is merely clarificatory and restatement of the position emerging from the principal provision. The proceeds of crime being the core ingredient of constituting the offense of money laundering, that expression needs to be construed strictly. In that, all properties recovered or attached by the investigating agency in connection with the criminal activity relating to scheduled offense under the general law cannot be regarded as proceeds of crime. There may be cases where the property involved in the commission of scheduled offense attached by the investigating agency dealing with that offense cannot be wholly or partly regarded as proceeds of crime within the meaning of Section 2(1)(u) of the Act, so long as the whole or some portion of the property has been derived or obtained by any person as a result of criminal activity relating to the stated schedule offense. To be proceeds of crime, therefore, the property must be derived or obtained directly or indirectly as a result of criminal activity relating to a schedule offense. To put it differently, vehicle used in the commission of scheduled offense may be attached as a property in the concerned case. It may still not be proceeds of crime within the meaning of Section 2(1)(u) of 2002 Act. Similarly, possession of unaccounted property acquired by legal means may be actionable for tax violation and yet will not be regarded as proceeds of crime unless the concerned tax legislation prescribes such violation as an offense, and such offense is included in the schedule of 2002 Act. For being regarded as proceeds of crime, the property associated with the schedule offense must have been derived or obtained by person as a result of criminal activity relating to the concerned schedule offense. This distinction must be borne in mind while reckoning any property referred to in the schedule offense as proceeds of crime for the purpose of 2002 Act. Dealing with the proceeds of crime by way of any process or activity constitutes offense of money laundering under Section 3 of the Act. Be it noted that the definition clause includes any property derived or obtained indirectly as well. This would include property derived or obtained from sale proceeds, or in a given case in lieu or in exchange of the property which had been directly derived or obtained as a result of criminal activity relating to a schedule offense. In the context of explanation added in 2019 to the definition of the expression proceeds of crime, it would inevitably include other property which may not have been derived or obtained as a result of any criminal activity relatable to schedule offense. As noticed from the definition, it essentially refers to any property including abroad, derived or obtained directly or indirectly. The explanation added in 2019 in no way travels beyond the intent of tracking and reaching up to property derived or obtained directly or indirectly as a result of criminal activity relating to a schedule. Location is in the nature of clarification, not to increase the width of the main definition proceeds of crime. Definition of the property also contains explanation which is for removal of doubts and to clarify that the term property includes property of any kind used in the commission of offense under 2002 Act or any of the schedule offense. In the earlier part of this judgment, we have already noted that every crime property need not be termed as proceeds of crime, but the converse may be true. Additionally, some other property is purchased or derived from the proceeds of crime. Even such subsequently acquired property must be regarded as tainted property and actionable under the Act. For it would become property for the purpose of taking action under 2002 Act, which is being used in the commission of offense of money laundering. Such purposive interpretation would be necessary to uphold the purposes and objects of the enactment of 2002 Act. Tersely put, it is only such indirectly as a result of criminal activity relating to a schedule offense can be regarded as proceeds of crime. The authorities under 2000 cannot resort to action against any person for money laundering on an assumption that the property recovered by them must be proceeds of crime and that a schedule offense has been committed. Unless the same is registered or pending inquiry by for the expression derived or obtained, illegal offense already accomplished. Similarly, in the event the person named in the criminal activity relating to schedule offense is finally absolved by a court of competent jurisdiction owing to an order of discharge, acquittal, or because of quashing of the criminal case against him or her, there can be no action for money laundering against such a person or person claiming through him in relation to the property linked to the stated schedule offense. This interpretation alone can be countenanced on the basis of the provisions of 2002 Act, in particular, Section 21U read with Section 3. Taking any other view would be rewriting of these provisions and disregarding the express language of definition clause proceeds of crime as it obtains as of now. I will come to this after reading 281 to 283. This para 253.
What is sum total of?
Sum total of para 253, I would put it, my lord, in relation to a schedule offense case by any one of the contingency, like quashing of the FIR, quashing of the complaint, or after investigation, they don't find material against a person, or a case wherein, though he is an accused, he is accused only in respect of offenses which is not schedule offense. In respect of proceeds of crime in that case, this person cannot be touched. I will elaborate it, my lord. Kindly allow me to read 281 to 283.
But there's one thing, give me one person, just a hypothetical example. The person may not be connected with that offense, everything, but suppose he.
I would, let me, academically, I would put it, my lord. If he has not been investigated for that schedule offense, yes, nothing comes in their way. They may call upon him to furnish information, this, that, etc., all those things. But if he is a person who was accused of that schedule offense and he has been, let us say, acquitted, he has been discharged, the proceedings are quashed, I would respectfully submit, not in respect of
Vacated offense proceedings have been quashed.
quashed. If that happens, I would submit, in respect of proceeds of crime, in that case, the person cannot be touched. They cannot step in.
Yes.
In 281, para 281, further discussion is made, my lord. The next question, my lord, got it, my lord? The next question is whether the offense under section 3 is a standalone offense. Indeed, it is dependent on the wrongful and illegal gain of property as a result of criminal activity relating to a schedule offense. Nevertheless, It is concerning the process or activity connected with such property which constitutes the offense of money laundering. The property must qualify the definition of proceeds of crime under Section 21U of 2002 Act. As observed earlier, all or whole of the crime property linked to the schedule offense need not be regarded as proceeds of crime, but all properties qualifying the definition of proceeds of crime under Section 21U will necessarily be crime properties. Indeed, in the event of acquittal of the person concerned being absolved from the allegation of criminal activity relating to schedule offense, and if established in the court of law that the criminal property in the concerned case has been rightfully owned and possession can be termed as crime property, and consequently proceeds of crime within the meaning of Section 21U as it stands today. On the other hand, in the trial in connection with the schedule of offense, court would be obliged to direct return of such property as belonging to him. It would be then paradoxical to still regard such property as proceeds of crime despite such adjudication by a court of competent jurisdiction. It is well within the jurisdiction of the concerned court trying the schedule offense to pronounce on that matter. 282. Be it noted that authority of the authorized officer under the 2002 Act to prosecute any person for offense of money laundering gets triggered only if there exists proceeds of crime within the meaning of Section 21U of 2002 Act, and further, it is involved in any process or activity. Not even in a case of existence of undisclosed income and irrespective of its volume, the definition of proceeds of crime under Section 2 you will get attracted unless the property has been derived or obtained as a result of criminal activity relating to a schedule offense. It is possible that in a given case, after the discovery of huge volume of undisclosed property, the authorized officer may be advised to send information to the jurisdictional police for registration of schedule offense contemporaneously, including for further investigation in a pending case, if any. On receipt of such information, jurisdictional police would be obliged to register the case by way of FIR if it is a cognizable offense, or as a non-cognizable offense NC case, as the case may be. If the offense so reported is a schedule offense, only in that eventuality, the property recovered by the authorized officer would partake the color of proceeds of crime under 21U of the Act, enabling him to take further action under the Act in that regard. 283. Even though 2002 Act is a complete code in itself, it is only in respect of matters connected with offense of money laundering, and for that, existence of proceeds of crime within the meaning of Section 21U of the Act is quintessential. Absent existence of proceeds of crime, as aforesaid, authorities under the 2002 Act cannot step in or initiate prosecution. If this is read with what is the finding recorded in para 253, I will, of course, there are two things, my lord. First is, I am driving at a stage where they cannot simply keep on saying, we are just trying to find out, we are gathering information, therefore we are summoning, we are doing all those things, without putting something in writing, saying whether a case is registered against me or not. Without that, they cannot simply say, no, it is simple summons, you come. For that, as the things stand, if read with 253, they cannot just step in, do anything in respect of so-called proceeds of crime in this schedule offense. That is,
What you are saying is being not part of the schedule offense, anything being asked from me cannot be construed as a proceeds of crime.
without that proceeds of crime being the prime, this thing being there, they cannot just in that proceeding, with regard to proceeds of crime of that proceeding, they cannot do civil investigation or criminal investigation.
Yes.
That is one of the second aspect of the matter is, the Lordship may kindly see, my learned friend pointed out and read the judgment pertaining to the Madras High Court for the Supreme Court quashed this summons. That matter ultimately was finally decided by the Madras High Court. Of course, decision is more on factual basis, saying there is nothing with the authorities at any stage, even remotely connecting the persons with the predicate offense is the finding. But interesting fact is, there were two sets of petitions filed before the Madras High Court. Your Lordship may kindly take paragraph G at the bottom, page 9. Page 9 of 66. G. I'm reading E, F, and G, my lord.
Yes.
In the meanwhile, I'm reading E, that would be page 8 of 66. In the meanwhile, summons were issued to all collectors in the state of Tamil Nadu in connection with the enquiry in the above referred ECIR. The state of Tamil Nadu and the collectors filed writ petitions number so and so, so and so. This court passed an order on 28/11/23 granting interim order of stay of operation of the summons impugned in those writ petitions. Some of the petitioners in the captioned writ petitions filed the writ petitions challenging the ECIR in so far as they were concerned in WP number so and so. This court passed an interim order of stay of operation of the summons issued to the petitioners in the ECIR proceedings. In certain other captioned writ petitions, court granted stay of the ECIR proceedings against the petitioners and also stay of provisional attachment order in WP number so and so. In the meanwhile, respondents filed a special leave of appeal in number so and so before the Honorable Supreme Court, challenging the interim orders passed by this court in the writ petition filed by the state of Tamil Nadu and collectors. The Honorable Supreme Court in SLP so and so was pleased to pass an order of stay on the execution of the orders passed by this court in those writ petitions. The Honorable Supreme Court had also observed that since the respondents are conducting investigation in the ECIR, the collectors are bound to respond to the summons. Consequently, district collectors were directed to appear and respond to the summons issued by the respondents. The respondents also challenged the interim order passed by this court in WP so and so before the Honorable Supreme Court. That is, individual petitions were also interim order was challenged before the Supreme Court. Honorable Supreme Court had observed that proceedings before this court would continue and directed the respondents herein to file their counter. Supreme Court observed that proceedings in the High Court will continue and the respondents will file the counter. Though the respondents herein prayed for stay of the order Honorable Supreme Court made the above observation. It is also considered by the respondents that the Honorable Supreme Court made above observation, though they had pointed out the earlier orders passed by the Honorable Supreme Court in these writ petitions filed by State of Tamil Nadu. Respondents have filed their counter in the above writ petitions. Then your Lordship may kindly see para 14, that would be page 41 of 66. Para 14. The learned additional Solicitor General submitted that when the interim order was passed by this court in a connected writ petition filed by the state and collectors of some of the districts in the state, challenging the summons issued to them, respondents had challenged the said order before the Supreme Court. Honorable Supreme Court in the SLP had made the following observation. Impugned summons have been issued by the petitioner ED in exercise of power conferred upon it under section 52 of PMLA Act, which reads as under. Then kindly come to, after quoting that section, kindly come to page 43. After quoting several case numbers, my lord, and since some of the offenses in that very para, last 5 lines, page 43.
Yes.
And since some of the offenses of the said FIRs are schedule offenses under PMLA, same would be the investigation proceeding under the PMLA, and the district collector or the persons to whom the summons are issued under section 52 of the Act are obliged to respect and respond to this said summon. The writ petitions filed at the instance of state government challenging the such summons issued to the district collector prima facie appears to be thoroughly misconceived, and the impugned order passed by the High Court also being under misconception of law, we are inclined to stay the operation of the impugned order. After the interim orders passed by this court, which were impugned in the special leave to appeal before the above said order was passed by the Honorable Court, this court had passed interim orders in the writ petitions filed by some of the petitioners and granted stay of the summons. Even after this court had passed the orders of interim stay of summons, it was represented by some of the petitioners that their properties were attached by provisional attachment order in cases after original applications were filed before adjudicating. We had granted interim orders in those writ petitions as well. Against one such interim order, respondents filed special leave to appeal in so and so, and the Honorable Supreme Court was pleased to pass the following order. Proceedings before the High Court will continue. The petitioners who are the respondents before the High Court will file their counter affidavit bar reply within 3 weeks. Ultimately, my lord, the Madras High Court has quashed the summons and entire proceedings, pointing out even remotely the petitioners are not connected with the so-called schedule offense case. As on that day when summons are issued, they don't have anything even remotely showing that they are connected or in any way they have it. That is what the finding is recorded.
For the investigation of schedule offense also, they can't call in.
Investigation of schedule offense will go on by other authorities, not by PML. That's a case registered under the IPC provisions.
But suppose.
Please.
Whoever involved in the schedule offense, there is a PMLA angle also.
Yes.
Can't they call him? Can't they call third parties or third persons?
Third persons, they can call. But what I am pointing out is, third person, in the present case, the petitioner cannot be treated as a third person.
That's what you're.
Please. Then, Miller, as your lordships noticed, all 5 petitions were jointly heard, though separate orders have been passed. The writ petitions 22780 of 23 is the only, your lordships get the cause title at page 17.
Let's see also, where is the case what you have argued now?
Please.
He set up before the learner single judge and what manner he deals with.
Please, Miller. Before that, let me just show the cause title.
Yes.
Page 17, cause title. WP 12451 of 21. That is by a person challenging the schedule offense, discharge application, etc. Challenging the schedule offense. 12423 of 21. Again, by the same person challenging the schedule offense, because schedule offense has been now made into year-wise, they have filed it as 3 charge sheets and 3 cases. Therefore, there are 3 writ petitions by that person challenging that. Then your lordships get WP 22780. That is the one now I am in appeal before your lordships pertaining to PMLA. Writ petition 22989 is again by the appellant, but it is in respect of an additional charge sheet filed against me, though not a schedule offense. Under section 44 of the PMLA Act, we advanced an argument before the learned single judge. Hearing, joint hearing, common hearing of schedule offense case and the PMLA case causes prejudice to petitioner and the other petitioners. Therefore, even under PMLA case, the provision is it should be independently tried, though by the same judge. That analogy may kindly be extended to writ petition, and we requested either first hear and complete the PMLA case. Thereafter, other cases be taken up, or other cases may be disposed. Thereafter, on the next day itself, PMLA case may be taken up, was also one of the submission made. The basis for making that submission is, my lord, section 44 of the PMLA Act.
So, Patil, we'll just come back in 5 minutes.
Yes.
Court officer.
Sir, really, sir.
Madam, ಇದು ಕಂಟಿನ್ಯೂ
ಹೇಳಿ.
2:30 ಸೀರಿಯಲ್ ನಂಬರ್
ಬರ್ತಾರೆ ಸರ್ 5 minutes 5 minutes.
ಓಕೆ
ಸರ್ 1 ನಿಮಿಷ 5 minutes ಬರ್ತಾರೆ ರೆಸ್ಯೂಮ್ ಆಗುತ್ತೆ ಕೋರ್ಟ್ ರೆಸ್ಯೂಮ್. Court will resume by 5 minutes, sir.
I was submitting, my lord, that except WP 22780 of 23, all other matters pertain to by accused in schedule offense case or another crime. All of them were clubbed together and heard. Section 44 of the PMLA Act notwithstanding anything contained in the Code of Criminal Procedure 1973, an offense under section 4 and any scheduled offense connected to the offense under that section shall be triable by the special court constituted for the area in which the offense has been committed. Provided that special court trying a scheduled offense before the commencement of this act shall continue to try such scheduled offense. Special court may, upon a complaint made by an authority authorized in this behalf under this act, take cognizance of the offense under section 3 without the accused being committed to it for trial. Provided that after conclusion of investigation, if no offense of money laundering is made out requiring filing of such complaint, the said authority shall submit a closure report before the special court. C. If the court which has taken cognizance of scheduled offense is other than the special court which has taken cognizance of the complaint of the offense of money laundering under subclause B, it shall, on an application by the authority authorized to file a complaint under this act, commit the case relating to the scheduled offense to the special court, and the special court shall, on receipt of such case, proceed to deal with it from the stage at which it is committed. Special court, while trying the scheduled offense or the offense of money laundering, shall hold trial in accordance with the provisions of the Code of Criminal Procedure as it applies to a trial before the Court of Session. Explanation. 1. Jurisdiction of the special court while dealing with the offense under this act during investigation, inquiry, and trial under this act shall not be dependent upon any orders passed in respect of scheduled offense, and the trial of both sets of offense by the same court shall not be construed as joint trial. 2. Complaint shall be deemed to include any subsequent complaint in respect of further investigation that may be conducted to bring in any further evidence, oral, documentary against any accused person involved in the offense for which the complaint has already been filed, whether named in the original complaint or not. This question, validity of this section itself was challenged in that Vijayalal case, my lord.
What is the submission?
Submission that I am making is, in this, the Supreme Court, when the validity of this section came up, made 3 observations. It said 44(1) should be, though there is it starts with the word notwithstanding, it should be read down as a discretionary. Trying schedule offense and the PMLA case offense by the same special court is read down as discretionary. When it came to that the authority under PMLA Act can file an application to call the schedule offense case also to the special court. When it came to that section, there again the Supreme Court said it is a enabling provision to be resorted only in exceptional cases. It may not be
What is the relevance in so far?
in relevancies, and if called for, Supreme Court said it should be kept in mind that it is not joint trial. Each case will have to be tried independently. Everything independently. Of course, I'm not saying section 44(1) is applicable to present writ proceedings or anything. That's not my case at all. But I am pointing out, in reading down these provisions and adding that word of caution, etc., Supreme Court definitely had kept in mind the prejudice that is likely to be caused to the accused if it is to be a joint trial
Held by the special court.
held by this special court, same court. It says, of course, there can be by the same court.
Where is the now issue here, at least in this appeal?
I'm only pointing out this matter, WP 22-780 pertaining to PMLA case, was jointly heard along with other cases.
That we are saying that what was done by the learned single judge could not have been done.
It was not, that definitely caused prejudice, would be my submission. With this, now I will read, as your lordship's directed, what has been said about my case by the learned single judge. This case starts from para 23, page 44.
Page number
In respect of the one for which the appeal is filed. That would be ink page 44,
Yes.
typed page 28. It is now settled in view of the judgment in Honorable Supreme Court in Vijay Madan Lal Chaudhary that an offence under PMLA Act would be attracted only when any of the offence mentioned in the schedule to the PMLA Act is registered. The authorities under PMLA Act cannot prosecute any person on notional basis on the assumption that a schedule offence has been committed unless it is so registered with jurisdictional police or pending inquiry or trial by way of a complaint before competent forum. It is also equally well settled that the registration of ECIR cannot be equated with the registration of an FIR, as the said document is an internal document for the purpose of enforcement directorate. The proceeds of crime as defined under section 2(1)(u) of the Act is dependent on illegal gain of property as a result of criminal activity relating to schedule offence. The position of law is well settled that when once the accused is acquitted in the predicate offence, or if it is quashed by court of competent jurisdiction, or if he is discharged, there can be no offence under the provisions of PML Act. With these prefatory notes, if the case on hand is perused, petitioner was chairman of DCC Bank during the period so and so, from 97-98 to 2015-2020. It was during his tenure that a statutory audit disclosed several deficiencies and lapses in the town branch of the DCC Bank, in as much as accused number 1 was appointed as senior assistant at the branch, though was promoted between 2005 to 2014, yet was continued in the town branch of the bank, though there wasn't any promotional post at the town branch of DCC Bank. Separate charge sheets are filed against accused number 1 and others for sanctioning gold loan to friends and relatives by accepting fake ornaments, and in many cases, gold loans were advanced without getting the gold pledged. In many cases, it was alleged that the loans were dispersed to many customers who were the relatives of accused number 1. Your Lordship may kindly notice accused number 1 is not the present appellant. This I am pointing out because my learned friend somewhere twice he repeated that 35 relatives, etc., have been given loan. Probably my learned friend has not been properly instructed with regard to that information. It refers to accused number 1 there. It was alleged that accused number 1.
This petition where the findings were given is not relatable to the appellant.
These findings is not relatable to the appellant, except that I was chairman of the bank at that time.
But he was working as senior assistant, everything was.
That is accused number 1 in schedule offense case. It was alleged that accused number 1, with the help of accused number 15, had misappropriated 62 crores belonging to the DCC bank, and accused 15 had not taken any action. The petitioner was charge sheeted for the offences punishable under section 409(202), read with section 36 IPC in CC number so and so, which were not scheduled offences under the PML Act. Therefore, apprehension of accused number 15 petitioner that he is sought to be prosecuted under PML Act is wholly unwarranted and baseless. The petitioner was issued with a summons by respondents to appear before them. The power to issue summons under PML Act is found in section 50 of the Act, which is taken to section 61 CRP, which is akin to section 61 CRPC, and reads as follows. The very reading of previous paragraph shows how the narration of case in schedule offense has directly taken into consideration in considering my case under PML Act. After quoting section 50, kindly come to page 48, para 24. A perusal of section 50, subsection 2 of PML Act leaves no doubt that Enforcement Directorate has power to summon any person whose attendance it considers necessary, whether to give evidence or to produce any records during the course of any investigation or proceeding under the PML Act. It could be that Enforcement Directorate requires the attendance of the petitioner to give evidence or to produce any records in respect of schedule offences committed by the other accused. After all, allegation was that accused number 1 had the benevolence of the accused number 15 petitioner herein, and therefore he was bound to assist the Enforcement Directorate, and this did not in any way prejudice the petitioner. This apart, petitioner was accused of an offence in crime number 4 of 2014 for the offences under section 31(1)(e) read with 13(2) of the PC Act 1988, and a charge sheet was filed on 20th March 2018. It could be that summons was issued to the petitioner in that regard. It could be that. Under this circumstance, petitioner cannot challenge the issuance of summons, and his apprehension that he is sought to be prosecuted for an offence registered in this regard, it is apposite to refer to the findings recorded by the Honorable Apex Court in the case of so and so. Summing up in para 467 has been quoted. After quoting the para 467, the reliance Even otherwise, there is nothing on record to prejudge the case whether summons was issued in respect of charge sheet filed against the petitioner in under section 13(1)(e) or section 13(2) of the PC Act, or to take further steps in the matter of investigation into the offences against co-accused. Therefore, all the contentions urged by the learned senior counsel for the petitioner in assailing the summons issued to the petitioner are liable to be rejected and accordingly rejected.
So there is a charge sheet under 13(1)(e).
Yes.
These are not scheduled offense.
Yeah, those are scheduled.
They are scheduled offense, my lord. It was disclosed only at the time of argument that this also is taken as a predicate offense. Then I filed the writ petition.
Say then there is no predicated offense, how relevant would be that? Today there is any predicated offense? which-
Yeah, in fact, my lord, the predicate offense continues. This man may not be an accused there for the predicate offense.
But this 13(1)(e) and 13(1)(2) is not against him.
Yes. It is against him.
But these are predicated offenses.
Yes, my lord, they have very much predicate offense.
No, but then why is being, the impression is given that he is not accused of any predicated offense?
No, that's not correct at all.
Mr. Patil?
Please, my lord. That's what I pointed out the other day, my lord. This offense under 13(2) and 13(e) was at the argument stage said that this is being considered, it can be. They don't say that there is this predicate offense is there, therefore we want information. On the other hand, they say this could be a reason for issuing summons. Then I challenged the sanction, given a sanction given for prosecution under 13(1), 13 Roman 2 and 13(1)(e), and the
So it is not a case, there is no predicated offense
No,
against
it
him.
is.
It is not a case.
No. Even otherwise, my lord, the predicate offense against the co-accused is continuing.
Against the co-accused.
Co-accused, it is continuing. Those proceedings are ongoing.
You're right. There are two things. There is no predicated offense for which there is an allegation for him.
No, under the PC Act there is.
The PCR, that's what we want to know. The impression we are getting is it's only 409 and those things which are not predicated offenses.
No, I'm sorry. The 13(1)(e) under PC Act continues.
It's continued.
Yes, continue.
So there is a predicated.
There is a predicate. Yes.
please, again,
Was only maybe came to know during the arguments according.
during the arguments, it was brought to the notice that it could be. Your lordship may kindly see the word used. It was, matter was placed in a sealed cover to the court. Court says it may be for that. As far as that offense is concerned, I have given the copy of the.
That finding. Page para 25.
Please. That accused number 1 had the benevolence of the accused number 15, that is petitioner herein, and therefore he was bound to assist the enforcement directorate, and this did not in any way prejudice the petitioner. Till here, it is about the case, the bank case, which is pending. There are other accused. Then the sentence. This apart, petitioner was accused of an offense in crime number so and so for the offenses under 13(1)(e), read with section 13(2) of the PC Act, and charge sheet was filed on 20th March 2018. It could be that summons was issued to the petitioner in that regard. Because that was an information in a sealed cover given to the court.
Yes.
when this was put up as a, because that was a case registered long prior to all these things came to light. As far as that case is concerned, sanction given for prosecution under 13(2) and 13(1)(e), I challenged it in a writ petition, which I have given the copy of the stay order, my lord.
Have you challenged?
Sanction given for taking the proceedings under 13(2) and
Sanction given?
that sanction was given, the date of sanction is 2/2/2018.
Tell us one thing, Mr. Patil. So you are here, you are aware of that process.
Which became a predicated offense.
No, what we are only saying this. Very well. Possibly lack of counter affidavit or so. Maybe why the summons were issued, they could not have clarified it. But it is not a case that this stand or this observation of the learned single judge has actually came as a surprise to you. There is a predicated offense which has been registered under 13(1)(e) and 13. You're right. And that's a predicated offense.
That's a schedule offense. I'm not disputing that at all.
But the impression we were getting was that 409, that's not a predicated. No, they can't even come near you.
No, as far as this is concerned, my lord, as soon as this was cited as a schedule offense for which the court, it might be the word used for this offense.
What is this? If a person has he is part of a predicated offense, is registered against him, can't they summon you?
For that, my lord, I would now point out this predicate offense is state.
Is state.
Is state.
Oh.
I challenged the sanction order. Writ petition is entertained and an interim order of stay is
So
granted.
what follows?
What follows is, as of now, till that predicate offense interim order continues, they will have to put their hands off. And it definitely is a case, my lord, wherein lack of filing a counter has definitely prejudiced us in prosecuting the petition with all this. Everything came to light at the stage of arguments.
No, but whether can you say so? Can you say so when you are aware there is a 31(e) registered? Sanction issued, you challenge the sanction has been stayed.
It's not that I was not aware.
Right.
What I'm
Their case should have been at least mentioned or told in the court in a black and white, so that you are aware. That's all.
I'm aware, whatever was to be put up, etc., because with regard to that offense, if they were to issue something like about by the time that case was started, it is almost 6 years thereafter they took action.
Oh.
PMLA action was almost after 6 years.
Oh.
This, as your lordships noticed, the quoting of the proceedings in para 25 and 26 with regard to reasoning, it is with reference to the case in which I was brought in, dropped from this thing. A separate FIR filed for the same offense that was quashed by this court. Then they have filed now an additional FIR where they don't include schedule offense. It is that which is in effect referred to. would be this joint hearing in that sense definitely has caused prejudice. At least at the time of hearing, the learned judge also being a human, all these things in a way, there cannot be a compartmentalized dealing with the matter. It definitely influenced. If 44 as held by the Supreme Court to be read down, it should be independently tried, is something to do with this sort of prejudice that would be caused to the persons therein. I would respectfully submit, though not section as such, but on that principle, it would be proper that I'm not saying it should not be heard by same judge. I'm saying they should be heard separately.
Should have been heard separately.
Either way, whichever may be taken up first, over next case, like that. Without that, a joint hearing, though the learned judge passes separate, it is something which, according to us, has caused prejudice to the petitioners in considering their case.
Yes.
Because PMLA, they don't go into how that crime, proceeds of crime arose. That is not at all their concern. They say, in a case, proceeds of crime is there. They are only concerned with, there is a case registered in which there is a proceeds of crime. How it came, etc., all those things, they are not.
Okay. What else?
Please. Of course, my lord, as regards arguing of this point,
How long you will take, Mr. Patel?
I require about another, I think, reading some, another edition,
Can tell us.
about half an hour, my lord, 20 minutes to half an hour.
And how much you will take, Mr. Kamath?
In fact, my learned friend has actually argued today. I will need about half an hour, 40 minutes.
We'll have it tomorrow.
Tomorrow.
We'll continue tomorrow, then we'll be blocking the board. We have.
Yes,
other-
Lord. So tomorrow.
Just say that we have further heard Mr. Patel from the senior counsel to come up for further arguments tomorrow.
Grateful.
Please.
Lord, serial number 12, my lords.
Serial number 12.
My lords, serial number 12, I'm appearing for the appellant, my lords, in this matter. My lords, there is some my lords, some inconvenience today, my lords. There is with senior counsel. Senior is not well.
So I appear for the respondent, Lords.
We raised an issue on maintainability of this.
Yes, Lord.
Yes, at the request of counsel for the appellant adjourned.
Date, Lord.
10-3.
Oblate, Lords.
Next.
Serial number 13. Mahendra. 13.
For the appellant, my lords.
Yes.
Senior is on the legs, my lords.
At the request of counsel for the appellant, we notify.
10-3. Serial number 14. 14.
For appellant, madam. For appellant. Comply to in the course of the hearing.
What is this AWF stamps?
Advocate welfare.
Oh, advocate will request.
Stop.
What do you want?
There is all office objection, my lord. I'll comply with in the course.
But there is some more objections very well. Will you argue the matter?
No. I'll have it till next week.
Just at the request of counsel for the appellant. We notify. Just say this also, the counsel for the appellant states, objections have been removed, the registry to give its report.
11-3, serial number 15. Can-
I appear for the appellant, my lords.
For the
I
respondent.
filed a memo for withdrawal, my lords. Withdrawal.
Just say this, the appellant has filed a memo for withdrawing the appeal. The memo reads as under. In view of the memo, the appeal is dismissed as withdrawn.
16.
I'm appearing for appellant. Kindly pass over, my lord.
Also was difficult today.
That's, no, the objection is with respect to limitation. Sorry, we have challenged both the limitation IA and dismissal, my lords.
So we'll have it some other day.
That's short accommodation, my lords. It is dismissed on limitation.
Short. We'll have the counsel for the appellant. Not possible to pass over the matter, re-notify on.
12-2. Serial number 17.
My lord, in this case, I pray your lordships leave to make a submission. I have not entered wakalat, my lord. I appear for the respondent, my lord. Just now I have received an instruction to file wakalat
Which respondents?
for all the respondents. Lord, I pray your lordship for a week time to make a submission.
So,
Yes, with hand summons I have received, my lord.
so appears.
K.R. Nagaraja, my lord.
Appears and states that he has instructions to appear for the respondent. Shall file wakalat within 1 week. Noting this submission, re-notify the appeal ground.
22. Serial number 18. Shri Vinay Kirti.
Appearing for appellant, my lordship. Kindly permit me to withdraw the appeal, my lordship.
Withdraw not the appeal, applications.
Yes, my lordship.
Appeal is dismissed.
Yes, my lordship.
Just say the counsel for the appellant has filed a memo for withdrawing the applications being 3 of 21 to 4 of 21. Just say this before that. You should only say applications, not appeal. Against the unserved respondent.
Yes, my lordship.
Or the only one respondent.
Yes, my sole respondent. We are not taking it. Once.
Unserved respondent. Although the appellant has filed an application 3 of 21 and 4 of 21 for recalling, for consideration of delay and recalling the order dated 11/9/2018, the learner counsel states that the applications are dismissed as withdrawn, and consequently the appeal is also, let's just say that the appeal and the applications are dismissed as withdrawn. Let's say that. Next. We'll come back after.
Serial number 19, my lord. We are supposed to upload e-filing, my lord. We request a week's time, my lord.
The request of counsel for the appellant re-notify.
May I make one request, please?
21, my lord. It's a plaintiff's appeal. My lord, there's some delay in the filing of the appeal. They have filed objections. I have not had a copy of it, my lord.
Number?
20. Respondent.
What do you want?
I want some time to look into the objections and then
The joint request, you both appear for the appellant and respondent.
he's for the respondent, I'm for the,
You are for the appellant.
I'm for the appellant, he's for the respondent.
A joint request re-notify.
Please.
15-3.
May I make one request? Serial number 13, my lords. Issue is with regard to maintainability, my lords. But this matter may kindly be, my lords may kindly recollect, my lords. Appeal under section 13. It's whether it is maintainable or not was issued. Ready, my lords,
We will have it tomorrow. Not today.
please.
Just re-notify. Who was the other side?
My
Anyone?
lords, no, notice is not yet.
Re-notify tomorrow.
12 ಅಲ್ಲ sir.
30,
12
That
Naveed Ahmed.
mine,
So sixth,
6th sir.
sixth February.
6th of February.
please.
My lordship, I seek your indulgence to mention item 45.
Yes, one.
There's this urgent relief we are looking for, so I was hoping it could be heard today. I've flown in from Delhi for this particular matter.
Which number, ma'am?
45.
Green one.
40,
45.
45.
You are there for the other side.
I'm there for the other side, Manoj. I'm respond number 1. They filed the appeal on 7th of January. Despite the caveat, Manoj, they only served me yesterday. Manoj, there's some difficulty today, Manoj. They served me only yesterday, Manoj, despite filing on the 7th of January. So, Manoj, will kindly have it any date next week.
But tell us one thing, who is the other respondent? Who are the other?
Yesterday at 7 o'clock.
All the respondents are here representing.
Yes.
You are for.
My lordship, the caveat had certain objections which was cleared.
My caveat doesn't have any objections. Then the cause basis. Despite that, Manoj, not so. So only when I reach out to the Manoj, they serve me. Manoj, can you have it any date?
Just say that you appear for the respondent number 2.
One appear for respondent number 1.
So at the request of counsel for the respondents, we.
7-3.
My lordship, can I get a shorter date? There's no.
Yes, what is the urgency?
My lordship, the urgency is that respondent number 1 and 2 are emboldened by I got an injunction from the civil court, but due to certain procedural issues, my injunction was vacated in the commercial court. Now there is no, can I please?
1 minute, let's see, just show us the file.
So right now, there is no injunction working in my favor. My ex-employee is going around giving this information to everybody.
But now you appear for the employees.
I appear for the employee, former employee. Manoj, in fact, appeared for the
Connected company.
But where is the employee here? Is he a party here?
He's a party, Manoj. Former employee is a party. He's respond number 1. I'm for the former employee.
Or one is the employee?
Yes, Manoj, former employee. Former employee. Yes.
His name.
Swatantra Verma. I appear for him.
We'll hear it, we'll have a short day.
Very well.
Let's give it in February.
Very well.
12-2.
Your lordship, when did he leave your organization?
He left in
In August, Manoj, last year.
In August 2023, there has been 2 rounds of litigations that have already happened.
We'll see.
Grateful, Manoj. Grateful. Grateful.
Serial number 32, my lord. Serial number 32. Suit for specific performance of agreement of sale. I am the defendant. There was no agreement of sale as such, and the trial court.
What do you want?
My lords, the matter is posted for execution on 1st of February.
Who is the other side?
I appear for the respondent.
We'll come back.
Sixth ಅಲ್ಲ ಮೇಡಮ್. ಮೇಡಮ್, ನಂದು 13, 6. ಅದು ನನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದ ಮಾಡಿ. ಮಹೇಂದ್ರ ಅಂತ ನನ್ನ ಜೂನಿಯರ್ ಹೆಸರಲ್ಲಿ.
7 ಇದೆಯಾ? ಅದು ಒಂದು 15
ಇಲ್ಲ, 6-2 ಅಂತ ಹೇಳಿದ್ರಿ.
ಸರ್ ಅದು ನವೀದ್ ಅಹಮದ್ ಆಪೋಸ್ ನೀವು 13 ಅಂದ್ರೆ ಸರ್.
ನಂದು 13. ಮಹೇಂದ್ರಜಿ. ಮಹೇಂದ್ರ. ಇಲ್ಲ, ಅದು 6-2 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Court officer. Madam Court officer.
Madam Court Officer,
ಮೇಡಮ್ ಹೇಳಿ.
ಇದು ಮಧ್ಯಾಹ್ನ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಲ್ಲ?
ಕಂಟಿನ್ಯೂ, ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮೇಡಮ್.
ಥ್ಯಾಂಕ್ ಯು.
ಆನಂದ್ ನೋಡಿ. ನಮ್ಮಿಂದನೇ ಕಳೆದೋಗಿದೆ ಅಂತ ಎಷ್ಟು ಗಲಾಟೆ ನಾವು ನಮಗೆ
On submission, my apology, my lord, the serial number 14, it has given long date, my lord. My colleague has sought an adjournment to comply the office objection. Lord, I'll comply it in the course of the day. It is given 11th of March, my lord. Shorter date, my lord. I sought an injunction. Others notice is not yet ordered. Fresh matter.
When will you clear the office objection?
Course of the day, I'll comply.
Just have it, in February second week, have it.
There any memo? You are moving memo?
Please preponing memo, my lord.
For what?
It was adjourned to 11/3, my lords.
today's list.
Today's list.
14, serial number 14.
It's advance.
14.
Just advance. Make it in this thing, February, make it February.
That you are to.
If you don't know that there are objections which you need to remove it.
At course of the day, I'll do it.
Tell the person.
That 12.
12-2.
Great.
Yes, next.
Serial number 20. With Priyanka, but.
Lordship, I'm on NOC Wakalat. Priyanka may kindly be removed. If my lord's word, she's given the NOC Wakalat to me in the matter.
Nothing. This appeal now survives.
Your lordship's
The last order. It shows you. You on the strength of the last order. Have you removed the objections?
All office objections are complied with, yes. Yes, your lordship. It's
Complied.
come up today for hearing on the application for condonation of delay.
What do you want? Tell us.
Lordships, my submissions are very limited, as is what is in the application. The appellants have health-related issues and age-related issues.
how
There's
is
a
that?
delay of 57 days. There's a delay of 57 days in filing the appeal. I had personally spoken to the party and they had said that they had some practical difficulties of getting the certified copies and identifying a lawyer. This is what they had told me, and I believe they had instructed the earlier counsel also the same thing. So there is a delay of 57 days. I'm having 3 judgments with me. If my lords were to see the judgment, these are in support of my contentions to say that.
Notice to R1 has to go.
In fact, notice has not been issued at all. In 2022, there was an office objection that was raised at the time saying BDA has to be served with a copy.
But how do you explain the delay?
No other reason, your lordship. They had practical difficulties at the time, health-related issues. My lords, I understand limiting my submissions to the condonation of delay. I have 3 judgments with me. In fact, 2 judgments, Supreme Court judgments.
27, number 20, RFE.
Okay. Date is 3. How many days?
57, your lordship.
57 days. Let's see this. You appear for whom?
Appellants, all the appellants.
R2, authority BD.
We appear for
R2 BD.
R2BD. Just say this application on 50 days, 57 days. Stated in the affidavit. The delay in filing the appeal, delay of 57 days in filing the appeal. Let's see your affidavit.
Notice to R1 is not on.
You know that, just 1 minute, please.
My apology.
The delay of 55 minutes in filing the appeal is condemned. Location disposed of. Issue notice, so and so accept notice for respondent number 2. That notice we issued to respondent number 1.
Grateful, Your Lordship.
Have you filed your wakalat?
I have, in December, I filed my wakalat, it's Anusha Devi H.
Just give the date.
17-3.
Your name is Priyanka Bhatta.
No, Your Lordship, Priyanka Asbat was the earlier counsel. She gave an NOC wakalat, my name is Anusha.
Say that. Is a good name?
Anusha Devi H. Your Lord.
So the name of so and so counsel shall be shown in the clause list in the place of Priyanka is. Next.
23, 21.
Appearing for respondent,
Yes.
filing objection to IM.
For
And appellant has filed an IA for dispensation of payment of court fee. I'm filing objection to the same. Madam.
And on 7th January order, Your Lordship, the TCR has to come from the civil court.
no, why have you filed this application? For dispensation.
See, I request some time to pay because 1,70,000 is the court fee. I request some time because I am not saying permanent discipline. So at least for 4 weeks to 6 weeks, in between any date, time is given, I'll make the payment, you will, as far as the court fee is
So how
concerned.
much time-
So regarding merits of the matter, I will argue the matter.
How much time you require? How much time?
4 weeks, Your Lordship.
Okay, so then the counsel for the appellant submits that the court fee shall be deposited within a period of 4 weeks. from the date. Just maintain that reputation also.
Okay, sir.
Then. So we will have it after 4 weeks.
Yes.
Just have it after 4 weeks.
In the meanwhile, let the TCR, because they are 7th January, Your Lordship was pleased to pass an order to secure because the question is raised regarding limitation, Your Lordship. These documents are available there. That agreement and other thing. Also judgment copy.
We'll file your court fee, we will hear you.
Because along with memo, I filed a earlier judgment copy, Your Lordship. In that, these documents, which now the plaintiff has relayed before the trial court, were all part of that document. So the continuation running date, everything is been, and that suit has been dismissed on the ground of limitation. Same issue because instead of, because that suit has been dismissed. Now that documents are all, subsequent documents are all given to the plaintiff in another court. And on that, the decree has been passed. So that's why I requested for.
Deposit the court fee, then
Yes,
we will
yes.
definitely call for it. Okay?
Cool.
Next.
19-3. Serial number 24.
Let them not precipitate the matter because they,
We say nothing. We will not say anything.
yes.
Okay? Thank you.
24, Siddhamalappa.
Appearing for the response.
Appear for appellant, please, Lord.
I have made these 2 applications, my lord.
I request weeks time to file objection to IA 3 and 2 and 4 of 24, please, Lordship.
The last occasion, my lords have given them time, my lord, to file objection.
The last occasion, the matter was the rectification of office objection. I request time, please, Lordship. They have moved the memo.
These applications are for what?
For
One
39
is
to
for not to alienate the property, my lord, and the other one is, my lord, not to change the nature of the property. So it's for the agriculture land, my lord. I have the decree of specific performance. I have deposited the entire amount, my lord, as directed by the trial court.
Please say.
During the pendency of the suit itself, Your Honor, I have constructed some shops in the suit schedule property. The property is adjacent to APMC ad. In opening the APMC ad himself, I have constructed, please, Lordship. During the pendency of the suit itself. It is not now. They have given a photograph before this court, Your Honor, some structures. It is already constructed and shops are. Please,
So that at least they will be aware what is the position.
Please, Lordship.
I had the
I did.
benefit of an interim order, my lord, in the trial court, my lord.
To the extent.
Not to alienate the property. my lord.
Are you alienating the property?
No, Lordship.
Well, we'll record his submission.
Please, Lordship.
We'll record his submission.
Yes. The decree is in their favor. How can I alienate the property, Lordship?
Two and three. These are two applications filed by the respondents. Respondent, sole respondent. With the following prayers in the application. Just reproduce the prayers in the application. Learned counsel for the appellant states that he intends to file a reply to the applications. So according to him, during the pendency of the suit before the trial court, he had made, the appellants have made construction on the
Please, Lord.
land. Insofar as the plea of the prayer for the prayer for not to alienate, for not alienating the scheduled property is concerned, the learned counsel for the appellant states that the appellants shall not alienate or create third-party rights and oblique or create third-party rights with regard to the scheduled property during the pendency of the appeal.
Please, Lord.
Okay. Then,
As far as the construction is concerned, my lord, the statement, it appears, my lord, is not correct. I produced the copy of the, my lord, the photographs. Recent, construction is very recent.
maybe recent. Ultimately, what has been decided by the trial court, it's only your rights have been determined.
Yes.
There is no, was there any impediment in terms of the decree, not that he could not have done it?
They have,
And mind it, his statement is during the pendency of the suit, he has done it.
Lord, I have produced the photographs, my lord, while constructing, my lord, we have taken the photograph.
We will ask him to file a reply also.
Please.
To that. So,
Please.
so one, your application for.
Not to alienate, my lord, my lord, that can be disposed of, my lord.
In view of the statement made by the learned counsel for the appellants, the application being 2 of 24
Yes.
is disposed of. Insofar as application IA 3 of 24 is concerned, the learned counsel for the appellants shall file a reply.
Please, Lord.
How much time?
10 days time, everything.
2 weeks to file reply to the application. Rejoinder be filed within 2 weeks after list on.
7-3,
Grateful.
Next.
till number 25, Ananta Narayan.
I appear for the appellant.
Yes. Yes.
This appeal is filed by the these plaintiffs in the trial court. Their suit was for declaration and permanent injunction in respect of the suit scheduled property which is agricultural land measuring 1 acre 334 gunters in Bangalore South Taluk. The suit came to be dismissed mainly on the ground that the identity of the land has not been proved. Against that, we have come up in appeal. Well, during the in regard to the suit scheduled property, there was a revenue appeal in respect of mutation entries. It stood in the name of the fifth defendant. It was challenged by the first defendant. During the pendency of the revenue appeal before the assistant commissioner,
a commissioner came to be appointed. Taluk surveyor was appointed as commissioner to measure, to inspect, investigate the land, demarcate the lands which are in the possession of the plaintiffs and the defendants. Exhibit D1 is this, said P1 is the order of the assistant commissioner. During the proceedings, exhibit P1, the assistant commissioner obtained the report wherein the revenue authorities have earmarked the land which is in the possession of the plaintiffs.
What is this IA?
ISR, there are 3 applications filed. One is for impleading the legal representatives of the deceased plaintiff number 1. We are 3 plaintiffs. First plaintiff died, and during the pendency of the suit, his LRs have not been brought on record. Therefore, I have filed IA number 1.
Have they initiated any execution?
No, man, no.
Let's say issue notice on the as well as on the application. Now, the respondents, insofar as the respondents, 1 has expired,
Defendant number 1.
defendant number 1 has expired.
Yes, ma'am.
So you are bringing the LRs of those respondents. But you have already brought them in.
They have already brought on record. First,
Were they there before?
yes, they were there in the trial court. The persons who were not brought on record are the LRs of the deceased first plaintiff.
First
Plaintiff. Unfortunately, we were,
the plaintiff,
yes, Malla.
Yes.
Anantaya.
First plaintiff,
K. Siddhappa.
Hanumantayya. Alla,
K. Siddhappa.
K.S. Siddhappa, quite right. And then the third defendant also,
Of Siddhappa.
they are respondents 7 to 17. ಅಲ್ಲ ಅವ್ರನ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡಕ್
ಅಲ್ಲ ಈಗ ಮಾಡಕ್ ಹಾಕಿದಿರಲ್ವಾ?
ಹಾಕಿದ್ವಿ.
Now they filed application for the, to bring the LRs of the plaintiff number 1 case. It has to be discussed.
As additional respondents 8 to 22.
ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ಗೆ?
ಹಾ,
3.
ಫಸ್ಟ್ ಪ್ಲೇಂಟಿಫ್ ಸತ್ತೋದ್ರಲ್ಲ,
ಹೌದೌದು.
ಅವ್ರ ವಾರಸದಾರರಿಗೆ I have filed application to implead them as
Correct. Yes.
respondents 18 to 22.
Correct. Now they filed application. In the loss of Siddhappa as a response.
Since they have not joined the present appellants, though they were first plaintiff.
Correct, correct.
Then the third defendant also died even before the judgment. Third defendants LRs are also
Issue notice on the appeal as well as the applications. Okay. Returnable on.
17-4.
May I, there is one more application, Malak, IA number 3, wherein I have prayed that during pending the disposal of the appeal, the respondents 7 to 17 be restrained from alienating the suit property.
What was the position before the court below?
Yes, there was an order that they should not alienate.
Just say this. No, show us that.
Yes. The fifth defendant, this is the order which was.
Today your suit was dismissed.
I understand, Mala. It is dismissed. Now, taking advantage. Just go to the.
You serve them for, you serve them first. Okay? We'll have it in first week of March. This returnable loan. Just give this to me.
7-3.
Okay.
26, 27 urgent, 28. Serial number 28.
My lord, I appear for the respondent in this case, my lord.
Yes.
Please, madam, this is appeal by the claimant. The claim petition came to be dismissed, and section 34 petition is also dismissed. But the claimant was awarded with the work of construction of road under overbridge, RUBs, at two locations, my lord. Location number 45 and 76. There are. But initially, the contract was up to 31/3/2014. When the LOA was issued, my lord, it is 3 months, and during initial 3 months, my lord, I was given the location for LC number 45, and casting of boxes was complete. And there was no instructions regarding launching.
No instruction regarding?
Launching of the boxes, inserting them under the road. In the second, I have sought one extension, and extension was granted up to 30th/7/2014. And during this during that extended period, boxes were cast for the second LC also. By 7/6/2014, casting was also completed. But a contract has come to an end on 30th/7/2014, and I did not seek extension because there was no instructions from the railways as to when it has to be inserted. On 30th/7, when I had given them a letter saying that you have to give me 20 days advance notice for insertion, because I have to arrange for 400 metric ton capacity crane. That comes 18 lakh rupees per day is the hiring charges. Therefore, I needed 20 days advance timing. I asked. They did not give any instructions during extended period. Therefore, I have not carried out the work afterwards. But their letters, the railways have started a series of letters from 23/10/2024, 23/10/2014 onwards. They have written me a series of letters saying that now we have obtained CRS sanction for insertion. Roadblock is obtained, therefore you have to start the work immediately. That is the letter that they have given. But my submission is, after 30th/7/2014, there was no contract in existence, and I cannot be compelled unless contract is extended either by mutual consent or by their letter by the respondents. They cannot insist upon completion of the work from me. And this was our contention before the tribunal. from 23/10/2014, they wrote me a series of letters and then proceeded to terminate the contract. By 17/20 on 18/11/2014, they were terminated.
18/11.
2014. But therefore, they terminated the contract and forfeited my performance gain, 5% of the contract amount, and SD, whichever is available, that also they have forfeited. Therefore, we have initiated arbitration, saying that there was no subsisting contract between us, therefore they cannot impose penalty. That is my contention before the trial court.
What was the reason that work could not be completed?
But there was no instructions from the railways for insertion. They have to take CRS permission and the line block they have to obtain. It is a running track between Bangalore and Dharmavaram.
Yes.
Therefore, they need to take CRS in permission for roadblock and stoppage of train for certain period. That was not there during subsistence of the work. Therefore, after 30th/7, I did not ask. They said on 23/10/2014, 3 months after the expiry of the contract, they said now we have obtained CRS.
Was there any termination before 31/7?
No, my lord, there is no termination.
So you want to continue the work?
No, my lord, that it was not extended by mutually.
Was there any request by you to extend beyond 31/7?
No, my lord, I have not did that.
Very well, neither you had asked, neither they have terminated.
Yes, my lord.
So for all purposes, the contract was not terminated, was on.
Contract was not on, cannot be said, my lord. Unless it is extended, I cannot be compelled to.
Did you express yourself?
Yes, my lord, I have said.
Express yourself, look here now, where is that?
My exhibit, my lord.
What is the finding of the arbitrator?
My lord, arbitrator, my lord, has, by referring to those letters by the railways, a series of letters, arbitrator, my lord, at paragraph 35 says that I have abandoned the work. That is.
What is wrong in that?
My lord, unless this contract is mutually extended.
You are right.
Yes.
But there is a termination clause.
Yes, my lord, there is a termination, but.
Could have also terminated.
My lord, before that, they could have terminated during a currency.
No, you could have also terminated. You could have.
I have resigned. Yes, I could have. Yes.
You have not terminated, neither you are doing work. What does that mean?
I said, my lord, I have said this after expiry, my lord, I have written a letter to the railway saying that give me 20 days advance notice and revision of rates has to be worked out unless.
The reason.
That is that letter we have sent to the railway, but they did not concede.
My lord, may I make a submission, my lord?
If they had revised the rates, you would have continued.
I would have.
Obviously.
Yes, ma'am, that's.
So in a way, it's not a case that it has come to an end by a flex of time. It is not such a case. You have given a request for revision of rates.
I did not give any letter for extension of time.
No, you did not. You have asked for revision of rates.
Yes,
So you are waiting for. So you can't say it will come to an end by a flex of time. Now let's see the finding of the arbitrator.
please, madam. Last time, kindly come to.
Where does the learned arbitrator deals with? You are
Please.
not.
Para 34, my lord, you lost me. Page 58.
Yes.
Time limit for completion of the work was 3 months and the set period as per LOA was expired on 2/4/2014. The work was not completed within the set deadline is not in dispute. At the request of the claimant, currency was extended up to 30th/7/2014. The claimant did not submit the bar chart despite request being made by the respondents as per Exhibit P4 dated 15/3/2014. Thereafter, the railways informed the claimant to transport girders and cribs. And in this connection, the correspondence produced by the claimant himself are dated 21/8, 22/8, 23/8, 3110, 311. To all these letters, the claimant does not respond. On the other hand, without referring to any of these letters, claimant writes to the railways on 511, putting several conditions and also seeks for rate enhancement by referring to other tenders. In other words, the claimant does not comply with the repeated request by the railways to transport girders and trips and does not even reply to exhibits P6, 6A, 8 and 9, but puts a condition on railways to proceed with the work. If the claimant was keen on completing the work, even after 30th, nothing prevented the claimant from taking steps in response to the communication sent to him on as per exhibit P6. But all those letters, my lord, came after expiry of the term. My letter is dated 5/11/2014 in response to their letter asking me to transport this. Even though the correspondence of the railway reiterate the urgency of the work, public safety, caution order, etc., the claimant turned a deaf ear to all these letters and all this current, but writes only on 511 without even referring to these exhibits. My lord, this finding, my lord, is not based on factual correct. My lord, all these letters reached me only on 411, my lord. Therefore, I have written the letter on 511. These letters, even though they were dated on 3110, 311, all those letters, they did not reach me before 511. I have produced the postal tracking. See,
Did you write, when did you sort your, wrote a letter to them for their enhancement?
511. When they issued
You wrote on 511?
on 511.
So what were you doing between July and November?
But there was boxes were cashed. It is
What were you doing? You were not working on the contract.
But after casting of box until it is pushed into the road, there was no other work to be carried out by me.
Right.
But the boxes were cast separately outside,
Right.
and they have to be pushed only when they give me the line block and
So when did you complete the casting of the boxes?
For the first one, by 7/6/2014, casting of boxes for both the locations for
For the second, both the locations?
yes, madam. For the first, before
Now, did you write any letter after 7/6/2014? Look here, boxes are ready. This have to be inserted till such time you block the box
Yes.
line.
Yes,
I
madam.
cannot do it.
Yes, madam.
What is the response?
Please, madam. They did not write any letter to me.
Where is your letter?
Please, madam. My letter, madam, is exhibit. Madam, on 30th/3, I have written a letter. 30th in the first 2014 in the initial with reference to the above work was started on 10.
30th/3 is on the last day of the
Yes,
contract was getting expired.
yes, madam. 2/4.
What do you write?
We are waiting for line block working for insertion of RUBs. Please arrange to provide the line blocks for insertion and also inform block period 10 days before. So I can arrange required machinery like crane and proclane excavators. After the block period for the completion of balance work requires 45 days. Also, as per the requirement and as per the block program, please extend the currency by 30th/7/2014. This is the
What's your extension letter?
extension and sought for clear instructions.
Where is that letter? Show us.
Exhibit C and the documents are not there. Madam. Exhibit C5 is the letter.
Just show us that letter. So what response you got?
But they have extended by 3 months, but no instructions regarding insertion of RU
Instructions of?
for carrying out the work.
Okay. But were they required to inform you?
Please, madam, they have to,
Where is your letter after 30th of March to them? Is there any letter after 30th of March that I have not heard from you regarding line block?
yes, madam,
Because of which you are unable to insert the blocks. Where is that letter?
Aye.
Just show this. See, you'll wait for a reasonable period. And then say, look here, I am not hearing you. Send a letter on 30th of March. I am not heard from you. Where is your, you have to block the line, then only I can insert. Where is that letter? Yes,
but after,
that's how you will look. Huh? They have written, you have done your job. According to you, they have not done. They did not respond. You will say, look here, I have written a letter. I have been requesting them. And mind it, the request for extension is for certain reasons attributable to you. You have casted, you have prepared those boxes.
yes,
On the last day of the contract. 30th March, you are writing to them.
writing,
Oh, I have to insert.
yes,
Please block. Then there is no response. Very well, for that reason, they have extended the contract. So by July, you were to do that. Show us one letter between March and July, you have asked them. You have pursued your earlier communication.
madam, there is no such letter from us. And for the second location, casting was not complete in the first initial period because there they did not give me the land.
Oh.
The casting for the second location was completed by 7/6/2014 in the extended period.
My lord, may I make a submission, my lord?
Why the casting was not done?
But it cannot be done simultaneously. The caution orders will be separate.
That's one thing. Contract for both the places was for 3 months.
Yes, madam, that's the 3 months.
Your, how do you carry out is your outlook. So they want for 3 months, both the things need to be done. For you to say whether it could not have been done simultaneously, very well.
No,
But you are required to do it.
madam, if the line blocks were to be given, madam, I was ready to do it in the extended period because once the box was cast, it requires 28 days curing is required for that. Therefore, in the first location, it was ready by 30th/3/2014. It was ready for casting. The second location was ready by 7/6/2014. And
So Sampath is difficult.
madam,
37.
30th 7.
We are in 37. Appeal under 37.
Madam, 37. But my submission is the finding of the arbitrator that I have abandoned the work is not based on facts because even if they give me, like after casting of the boxes, if they give me the line blocks, then I did not do the work.
Show us one letter. Show us one letter
Yes.
after 30th of March, before 37. Show us one letter.
But there is, I have not written any letter, but there was no line block given before 30th/7/2014. But therefore, blame cannot be rest upon me.
I,
My lord,
but
one
you
submission,
are
my
doing your work. Look here, I am waiting for you. I am not getting that line block because of which I can't undertake this work. Show us one letter. You will say, I have written a letter on 30th of March, calling upon you to block the line. Till such time the line is blocked, I can't do it. Show us one letter.
Well, that's the only letter available, 30th 3. Thereafter, my lord, I have not written until 5/11/2014. I have not written any letter.
Sleeping, they were sleeping.
My lord, the boxes,
Obligation on your part.
my lord, boxes were cashed. My lord. The only if they give the line, then only I can cash it.
You will see in normal conduct of a human being. You wrote a letter on 30th March. You have not heard, and the time is running against you because they have extended the time till July. You have to do the work till 30th July. They were sleeping over it. There is an obligation on your part.
My lord, after 30th 7, by that time, for both places, boxes were cashed.
Difficult.
But the arbitrator then court has not said there was a default on part of the respondents also in not giving the block within the contract period. But
Let's see this finding of
liability is cast upon me to say that I have abandoned the work, therefore they are justified in terminating the contract. The contract was terminated after.
Let's see. Just show us one letter after 30th of March, one letter that you have written to them on till 30th of July 2014. One letter. So you had 4 months.
But in those communications, I have only said that the casting is complete in the second location also by 7/6, but there was no letter asking them to give me the line block.
The finding of you abandoning the work is right. 30th March till 30th of July, one letter show us. At least 1, 2, 3, 4 letters would show you are actively involved in the working and you have been writing through them. Did not write one letter. They think, oh, okay, very well, he has abandoned. That's the position.
But that abandonment, if it is during currency, if I have not done any work, any instructions is passed on to me, then I did not comply, then that it becomes abandonment. This, after I casted the boxes for the 2 locations, and instructions have not come from the railway for insertion, and they blame me that I abandoned the work. That is
Your own case, what you have now argued. Only one box was casted before 30th of March. Second was done on 7th of June.
But
to inform them the second is also ready, please, you have still not blocked the line, because of which I am unable to undertake the work. Was one letter of 7th June. This is your own case.
Yes,
you have casted the second box on 7th June to us. And according to them, their case is they have extended till 16/11/2014 your work.
that is the inference drawn by the.
Let's forget it. Let's forget it.
There was no actual.
Let's forget it.
The learned arbitrator, on the basis of those letters, comes to the conclusion that at least by 16/11, I should have completed the work. That is the inference the learned arbitrator.
Doesn't make any difference. Now tell us. That's what we are asking you. 30th March till 30th of July, just one letter shows.
But there was no exhibits were marked on the basis of.
Okay, thank you, Mr. Sambal. We will not.
Please, my lord, this is
37th
my lord,
jurisdiction.
my only before that, my lord, I will have to refer to only one judgment of the Supreme Court regarding.
Is that judgment?
This is regarding the application of section para 15. You lost my time.
Sarvesh Chopra.
Sarvesh Chopra. Para 15.
Para?
15. in our country, the question of delay in performance of the contract is governed by section 55 and 56 of the Indian Contract Act 1872. If there is an abnormal rise in the price of material and labor, it may frustrate the contract and then the innocent party need not perform the contract. So also, if the time is of the essence, the failure of the employer to perform a mutual obligation would enable the contractor to avoid the contract as the contract becomes voidable at his instance, where time is of the essence of a obligation. But here, my submission is that after 30th/4/2014, there was no obligation cast upon me to carry out the work. The instructions from the railway came only in the month of August and October.
We sought the extension.
But extension is up to 30th/7/2014, not beyond that. It was not.
That's still so. There is an obligation till 30th of
May-
July.
Please, my lord, yes.
Well,
My lord, may I make one submission, my lord?
when did you casted the second box? June.
During extended periods.
So in any case, in the initial period, you did not carry out any work.
No, my lord, for that also there is a reason. They did not give me the location for the second location.
No, my lord.
For casting of boxes, they did not give me the location for this thing. We need empty space for casting of the boxes. They gave only during extended period, therefore it was cast in the second.
This has to be.
My lord.
Please, madam, that's what my submission is. All the instructions and even CRS permission for line block was obtained for the month of November and December. During that time, my lord, there was no subsisting contract. CRS will not give permission unless contract is alive. This was came after 2 years. Initial period, they did not produce it before the court.
My lord, one submission, my lord. This contract was abandoned by the claimant, my lord, and subsequently the same work was awarded to another contractor, and he completed the work, my lord.
When did you award it? When did you award it to the new contractor?
My lord, in 2015, my lord,
Much after.
much after, my lord. Almost 6 months after the termination of this contract, we awarded the contract to another contractor, same
Did you
contract.
award at a higher cost or a lower cost? Did you award at a higher cost?
My lord, not at the risk and cost of the previous contractor, my lord. It was a fresh contract.
But they have
For that
forfeited
reason, my lord, we have to.
and BG, my lord.
You see, that's the effect.
Well, that is a bit harsh because unless they show that they have suffered loss, they cannot impose.
So the terms of contract say so.
Well,
Okay, we delay attributable to you. There is a consequence.
yes, ma'am. If
Then
it is a mutual obligation, the obligation cast upon them, my lord. It cannot be upon me that obtaining line block. Casting was done by me, whatever the work which can be done without their assistance, I have completed. Only because of insertion, they require railway.
authorities have gone against you.
My lord, that is arbitrator, my lord, by oral evidence, ignoring the material evidence, my lord, he has came to the conclusion that I have abandoned. That finding is factually
My lord,
incorrect.
the claimant has not put
That's
forth
the reason
any
why I've been
evidence
asking
regarding
you.
the.
Show us one letter, between 30th of March to 30th of July.
My lord, there is no letter, but there is oral evidence, your lordship.
That's enough for us to even conclude the same manner, that you have actually abandoned the work. If one has not abandoned the work, you would have returned to the railways, look here, I am ready, I have casted, please lock the line. I have to insert.
My lord,
One letter. Your own case is that you have casted the second one on 7th June.
even for my first letter, my lord, even for my,
Thank you.
even my first letter, my lord, they have not granted any reply was not came from them.
My lord, one submission, my
My
lord,
lord,
if the claimant was genuinely aggrieved, he might have even questioned the fresh tender which we have floated for the same contract. He had kept silent on that. He has never questioned the new contract also, new tender. Fresh tender was announced by us and a new contractor came into issues. That was also not questioned by him by in any court of law.
Well, that question will not come in the.
Very well. Dismiss. We'll pass orders. We are dismissing this. Thank you.
Much obliged, my lord.
Deny.
Appearing for the appellant in this case, my lord.
For the respondent number 1.
Respondents 2 to 5.
I'm appearing for the appellant in this case, my lord. I'm seeking for a short adjournment, my lord, as senior counsel is traveling to Delhi today.
Yes.
Kindly have it in next week, any date, my lord.
They say the request of counsel for the appellant has been. Just give our name.
18-3,
Much obliged.
30 adjourn, 31, Shri Rajeshwar, 31. 31,
Respondent.
I requested today morning, my lord. I intimated, my lord.
Want an adjournment.
I don't.
Yes, my lord.
Say the request of counsel for the.
90,
Give it in approval.
21-4, serial number 32,
Paper.
32. Shri
For the
Srinivas.
appellant. Paper, respondent.
Yes.
Defendant's appeal, my lord. Suit for specific performance of agreement of sale in respect of agricultural land measuring 1 acre and 7 guntas in Shirampura village of Chibalapur Taluk. It is said that the agreement was executed on 25/12/2015, 26/12/2016, 2015, and it was also read that the advance money was a sum of rupees 14 lakhs and the sale consideration was 16 lakhs. In this regard, it is the defense taken by the defendant that he has not entered into the agreement of sale as such. In fact, there was some documents taken by the plaintiff while he had assisted him in engaging a counsel to appear in another case in OS number 443 of 2007. That is a partition suit filed against this appellant by his vendor's children seeking for partition. And thereupon, this agreement of sale as such has been created. And in regard with the payment of advance money, it was specifically contended that the plaintiff contends that the amount was paid in cash in a sum of rupees 14 lakhs. He being a farmer, his specific contention is that 14 lakhs was paid as cash. And so also in another breath, he contends that he has documents to show that he had 14 lakhs with him and he'll produce the same, but he does not produce the same before the court as such. And the findings of the trial court in this regard at paragraph number 31. Page 36, paragraph number 30.
File your paperwork, will admit it.
Days. And execution, it is posted on 1st of February, my lord.
So we deposit the money.
Yes,
Deposit the money.
My lord, actually regarding transaction, there is not a,
10 years, will the money is lying with.
my lord, may kindly appreciate.
Uh,
Regarding payment of money, there is no conclusive evidence as to payment of money.
Will allow him to proceed with the execution. There is a money decree against you today.
Yes, in fact, I was about to say that.
Maybe rightly or wrongly, maybe you succeed in the appeal later. But today, when the money is there, you may have to secure. Suppose you were not to succeed in the appeal. That's all. So you deposit it, we will stay the execution.
My God, my lords may kindly appreciate.
We will surely. Not the law. The position of law. Otherwise, we say nothing. We will work it out before the executing court.
In fact, the information is that he is trying to sell that land to the.
No, I am not. There is, that contention is not.
Very well, then we will admit. Okay, then we'll call for the TCR. File your paper books, we'll hear. Yes.
Interim order, my lord, pending.
So deposit.
It's not possible for him because
You say nothing then. You say nothing, just say this, admit. That the paper books be filed within 4 weeks, TCR be requisitioned.
25%, about 25% within 2 months.
Is our prerogative to say.
Actually, my lord, in fact, it is clear from the evidence itself that
He will hear you.
please.
Yes.
Deposit 75%.
Not if it's a clear, I'm sorry. There's a clear finding, not that the exhibit.
You can see.
An amount is.
Suppose he has to succeed in the appeal. Then.
Yes.
And most importantly, even regarding refund of the alternative prayer for refund of the advance money also is not made in the pleadings as such. The apex court in
See, specific performance has not been granted. What has been granted is what he has paid. That's all.
Within 6% in this.
50%, 2 months.
Okay, very well. Then we say nothing.
50%, 2 months.
We have conveyed ourselves. We want, we will put it subject to that. If you don't pay it, deposit it, he'll proceed with the execution.
Great.
Just say
50% in 2 months time, my lord.
where is the stay application?
I filed my stay application.
Just say this, IA, subject to the appellant depositing.
50% money.
If
Please, man.
we will not say anything.
Please, man.
We don't like this interruption, please.
Please, man.
75% of the decretal amount.
In 2 months time, some time may be granted.
You will allow us to complete the order
Please.
computed as of today. Okay, within, to be deposited within a period of 8 weeks. There shall be a stay of the huge judgment decree dated 8/8/2022. In CS, in OS number 157 of 2017. On the file of the Constitution. 217 passed by the Principal Senior Civil Judge and CJM Chikkaballapur. Okay. Till the next date of hearing. Stop. And we will say so that if it is not deposited, he will proceed with the execution. It is also made, we have been informed during the course of hearing that the respondent has initiated execution proceedings. The execution proceeding shall remain stayed for 8 weeks by making it clear that if the amount is not deposited in the court within 8 weeks, the respondent shall be within its right to proceed with the execution proceedings. The amount to be deposited in terms of this order shall be invested in an interest-bearing FDR with periodical renewals till further orders.
Please.
Okay, application disposed of.
Please.
22/4. 33 adjourned. 34, Srimati Nayanatara.
My lords, I appear for the appellant, my lords. Senior is not in station. If a short adjournment may kindly be granted, my lords.
Respond number 1 and 2.
For respond number 3 and 4.
They say this agreement is sought by the council on behalf of the council for the appellant. We notify.
Interim orders may kindly be extended, my lords.
Interim orders if any to continue.
Much.
You appear for both of you appear for the respondents?
I appear for
I appear for respond number 1 and 2.
I appear for respond number 3 and 4.
Okay, please do it.
2/4, seal number 35.
Much obliged.
Seal number 35, Shri Rakesh Kini.
I am for appellant.
My lords, if it may kindly be taken on the 5th, my lords. There's some difficulty on the 4th. I apologize.
Madam, 2nd of April, madam.
Oh, April.
Second
Oh,
April.
perfect. Okay. Much obliged.
Bill number 35.
My lordship, I for appeal.
Yes.
My lordship, I for appellant.
Yes.
My lordship, this is the first appeal challenging the judgment and decree dated 21st July 2023, passed by the Commercial Court Udupi. And this is the case where the respondent is already under the moratorium. And my lordship, there is junior. The moratorium passed 1 year ago and the trial is continued even after different application filed before the Honorable Court. And the moratorium date is 15th July 2022 by the NCLT. My lordship, we see page number 4D.
What do you have?
Page number 4D, para number D of this list of documents.
You will file it, not like this. You will file
List of documents is there. I think junior is there.
List of documents.
List of documents.
Sir, what is?
Yes, my lordship.
These are list of authorities. Just take it.
List of documents is also there, my lordship. List of authorities also, list of document is also.
You will file it in the registry.
Okay, okay, my lordship, I just come to the case right now. This is a case where the moratorium in the NCLT passed by the Honorable Court, and I want to bring the judgment, recitation of, I want to bring.
What is the name of the counsel?
Just respondent.
Please, Ms. Rakesh Kini.
Rakesh Kini.
Page number 2, para 5. Page number 2, para 5. My lordship, they continued the proceeding even after moratorium, even after filing the interim application.
Which page 2, which para 5, of which document?
Page number 2 of the authorities, para 5 and 6.
Of which document?
Authorities relied upon.
No, we are not received. We have not received your authorities.
Okay.
You will file those documents in the registry, give a copy to the other side.
Okay, my lordship.
We just simply re-notify it. You will, whatever documents you have to file, and mind it, these documents must be the documents which were there before the court below.
Yes, my lordship.
Just say that, just at the request of counsel for the appellant, re-notify. You appear for whom? Is there any moratorium against, moratorium in your favor? Next, re-notify. Next.
18, 36 urgent, 37, Shihiramat, 37.
Yes.
The appellant filed a suit for partition and separate possession, my lord. The appellant and respondent 1, 2 are the brothers. 3 is the financial institute. The case of the third respondent is that the defendant number 2 obtained a loan mortgaging the property. But the learned and then defendant number 3 filed application to reject the plaint under Order 7 Rule 11, my lord. Without evidence and records, the learned municip has dismissed the suit for partition. Without recording the evidence and without going through the records and everything, my lord, partition suit dismissed on application filed by the defendant number 3.
For the application?
Under Order 7 Rule 11 to reject the plaint.
Cause of action. What was the ground invoked?
The suit is the scheduled property is mortgaged with the defendant number 3 by obtaining loan. But I have filed a suit for partition with my brothers. Appear to me.
So who appears for the respondents?
Shantappa. Shantappa DG. Ashwath.
File for record will position. Has it been admitted?
No, sir, only notice.
Just say that none for the respondents, re-notify. Just say that.
And the parties may kindly be directed to maintain the status quo, my lord. Otherwise, the respondent number three is trying to attach the property on Surface Act. The agricultural land doesn't come under Surface Act.
This was issued in 2023.
Please,
And you just moved the CH today.
Please.
Tell the lister, just at least you should have informed them. You inform the other side, will you be informing?
I have served the copy, my lord, before moving.
See, they may not be knowing the date. Or the dates listed, you inform them, we'll fix a date, inform them.
Please, man, next time I will.
Just say this, none for the respondents. The counsel for the appellant states that he shall inform the counsel for the respondents 1 and 2 about the listing of the matter today and the court adjourning the appeal to.
11-2. Serial number 38.
12, my lord.
11-2, sir.
12 to,
11th of
February.
I seek, 12th.
12 to, you want 12 to?
12th.
38.
Obliged.
Appear for appellant.
For respondent number 1.
Yes. Tell us.
Well, an appellant corporation had sanctioned loan of 600 lakhs rupees to the respondent number 2 in this case. And the second loan was second loan up to the tune of 1 crore 25 lakhs to the second respondent on 25th November 2013. And as a security for this loan, the respondent to number 2 had mortgaged 2 properties, collateral security, both movables and immovables. Property bearing number 4, situated at Achay Chetty Layout, Makery Circle, Sadashiv Nagar, Bangalore. And on December 2013, the first loan became NPA. First loan became NPA. On 17th December 2012, the another loan also became NPA. They became defaulter. And on the 31st July 2015, because of this default in repayment of the loan, the appellant corporation has taken over the possession of the secured asset, collateral security. We have taken over the assets on 31st July 2015. No, only one property. Collateral security we have taken. My respectful submission is the respondent number 2 established a multi-speciality hospital in the leased premises belonging to respondent number 1. That is property number 5, adjoining to their collateral security bearing number 4. And the respondent number 1 filed execution petition before the Honorable Trial Court bearing number 819 of 2017 because of the arrears of lease amount, the rental amount to respondent number 1.
Separate suit he filed.
On the basis of the arbitral award, arbitral award. And on 22nd February 2018, the Honorable Court, Trial Court passed an order for attachment of the movables belonging to respondent number 2. Those movables were in the leased premises of the respondent number 1. But my full submission is both immovable and movable assets are mortgaged to appellant corporation. Ultimately, the decree holder, got succeeded in the execution petition to get his leased premises vacant. So because of that order, the respondent number 2 shifted their movable assets to their collateral security bearing number 4. Now they are in collateral security bearing number 4. They are under the custody of the official liquidator of the Honorable Court as per the order passed by the Honorable Court only. Now, as per the information, we are in touch with the
this official liquidator,
File objections.
we have filed objection.
What is the official liquidator?
Official liquidator has filed
Which is, who is under liquidation?
the respondent number. My lord, he has filed company application number 314 of 2022, praying this honorable court to appoint a valuer, assess the value of the movables. Once the value of the movables are assessed, the lease, this collateral security will be handed over to the applicant corporation. We have already taken 13 advertisements, but no bidders were there for the collateral security.
But did you initiate any surfacing proceedings?
We have already initiated.
What happened to those?
No, the third phase, we have initiated proceedings, but as per this the respondent number 1 more before this appellate court, this honorable court, as per the order passed by this honorable court, the property was taken over by the official liquidator on winding up proceedings. Your lordship may kindly see page number 34. There are two schedules. The first schedule is property belonging to the respondent number 1.
But what steps you have taken to recover your loan amount?
No, we have taken, we have quoted 13 advertisements, but there were no bidders for this one. In the meanwhile, they moved an application for company application for winding up the company. As per the order passed by this honorable court, official liquidator had taken possession of the property. Movables.
Only movables.
Only movables.
So what was your claim? What was your application before the executing court?
To withdraw the attachment
On the movables.
Movables.
What does he say?
It was rejected by the trial court on 22nd.
Respondent number 1, the DFs are before the execution court.
It was rejected on 22nd August 2020.
The lessor.
Please.
You are the lessor.
Please.
Your lordship may kindly see page number 44 of the appeal in the page paragraph number 8.
Respondent number 2, the other respondent.
Notice, sir. Bills are laying in the collateral.
Let's see. The
Respondent number 2.
The diagram help.
One trust.
Diagram, no, he is belonging to trust.
Then who is the official liquidator? There is a liquidator for R2. There is a liquidator for R2.
No, liquidator to R2.
We have to issue notice to him. The notice been issued to the liquidator.
No, not yet.
How we have to do it? Who is it? What are the details of the official liquidator? Now today your claim is against 2. Your claim is against respondent number 2.
Respondent number 2.
Now is being represented by the official liquidator.
Yes,
He is an official liquidator.
Yes.
So obviously we have to, what are the details? Who is the official liquidator attached to this court?
Yes, sir. Well of this court. In another case, OL has submitted a report just before this honorable court.
Who was representing the respondent number 2 before the court below? Who was representing? When they filed this application, the liquidator was in place?
He was not in place.
No, was he appointed?
In company application, as per the order passed by this honorable court, property was taken over by the official liquidator.
Property means the movables.
Movables, yes. What happened after 17/8/23?
Winding up order was passed by this honorable court
Yes.
on 22nd July 2021.
So who was representing R2 before the court below? You have any idea?
Oh, I'll have to verify my notes. My lords, there are company petitions and company applications filed before this honorable court. It may be pertinent to place orders passed in all those matters on record before any orders are.
We have one order on the company petition.
Please.
It was passed on 22nd July 2021, my lord.
With
Winding up
apology, if I may make a submission, my lord.
Yes.
My lord, I was actually waiting for another matter, my lord. I represent the official liquidator attached to this honorable court, my lord. In case any assistance is required, my lord, in this matter, I can take notice, my lord.
We've been told this company has been wound up and an official liquidator has been appointed. This is by order dated 22nd July 21.
Please, my lord.
Now, this is with regard to respondent number 2 company.
Please, my lord.
Diagram healthcare limited.
The financial institution has filed objection. You know, there was a decree in favor of respondent number 1 in a different proceedings. They are basically lessor and lessee. So in the execution, there was an order passed and they filed an objection in the execution petition saying that the movables are, they have been given as a collateral security to this financial institution. Now they have to recover their dues.
Please, my lord.
So now in this background, now once this respondent number 2 official liquidator has been appointed, we just wanted to know that what would be who would represent respondent number 2 today?
My lord,
the official liquidator only.
please, my lord, it would be the official liquidator, my lord. In terms of claim, my lord, if
You can possibly take information from the official liquidator or so.
We will do
It's
it.
attached to this court only. Take
We'll do it.
information.
We will do
We'll just simply re-notify, get your instructions. Okay?
Yes.
And this follow it up, what happened after this official liquidator has been appointed again of this.
That's why
respondent number 2 company.
my respectful submission, he has filed an company application before this honorable court for appointing the valuer to assess the value of the movables.
Then
And
what
we
happened thereafter?
are spending about 42,000 rupees per month towards security and other incidental charges.
You must be active, na? To get your information.
Yeah, we will
Now,
do.
what happened after the valuation has been done? Has he sold all those movables?
No, a valuer has not been appointed by this honorable court. He is waiting for the orders of this honorable court.
The company code, in the company petition.
Company.
Must be there only, not here.
Here, before this honorable court only. Last para of his report, last para of this OIL report, it is there. Not before incident.
This is not in this petition. This is in a different petition. This is in a different petition, not in this petition.
Yes. We will follow it.
This is in petition 7294. Just give it back. You see this is not in these proceedings.
This is not in this proceedings, sir. He has submitted report in that proceedings, sir. But in the last para of his report, he has clearly stated that the CA number 314 of 2022 is before the Honorable High Court of Karnataka. Yes.
There may be other petitions also.
Yes.
So take all the necessary, information. regarding this, what is the stage? Then possibly you make your submissions, whether we need to bring in official liquidator in this case, that we will consider it.
May I make one short submission, my lord?
Yes.
My lord, if the appellant has any claim against the company in liquidation, my lord,
You can
and
make a claim there before the official liquidator.
please, my lord, he can file a form 66 with us.
That's another way out. If you have anything claim against the respondent, you will file a claim before the official liquidator. But we say nothing today. Get your all information, possibly, maybe you can take the assistance of your friend and all those things, get all your information, then take a call. Possibly, how much are the dues today?
10 crore plus even.
The secured debt, they are secured creditors also.
See, we are secured credit.
What would be their priority insofar as all their claims are concerned?
My lord, they would be ranking first, my lord, along with the workmen, my lord, under section 529.
Get all your information, we say nothing on this. Just say that at the request of counsel for the.
No, I pray the honorable court to continue the interim order. It was passed on 30th September 2024.
What is the stage you sought?
Attachment of movables. We have prayed the trial court to withdraw the attachment of
Withdraw the.
attachment warrant of movables.
No, you only sought this attachment.
No, we have not. That is a decree holder, respondent number 1. But actually, those movables are mortgaged to corporation, appellant corporation.
No, you have seen this order, just show this order. See this order.
That is regarding the permission to file that one.
Read the next sentence.
Interim order has sought till next date of hearing.
Who has sought that?
No, we have sought, but
What was the interim order you sought?
madam, IA2.
Oh, you have sought the stay of the execution proceedings.
The execution.
So execution proceeding must have been stayed now. Initiated by them.
Yes, please.
So very well. Very well, that remains stayed. It will continue, we will continue that. So they can't take it forward, those execution proceedings. The interim order, so and so shall continue. Is it continue? 11/11/2024. Thereafter. Interim order dated so and so, will continue interim order.
30th September.
It is 39/2024.
Please.
Shall continue till the next date.
My lords, the entire set of documents have not been served upon me, just the set of appeal.
Just give him a copy.
Yes,
Now get your information from the official liquidator.
we will get the information. I kindly pray for a date, even on the date.
He will give it.
24/3, serial number 39.
For the appellant in this matter, my lord.
I appear for the
Brief on
respondent.
This
in
matter
this
is not keeping well today, my lord. May I request for a week's time? It's keeping not well.
I appear for the respondent in the first matter, my lord, and I appear for the appellant in the connected matter, my lord, 39.
The respondent in 39.1.
Cross appeal
Next
side.
week, my lord.
I am ready, my lord.
Yes,
I pray for an adjournment, my lord.
he is seeking an adjournment here.
I leave it to your lordship, my lord. I also see the time as well. It may be heard at some.
Appellants re-notified.
25/3,
Next.
May I request, my lord, can it be had on 12/3, my lord, if it is convenient? 12.
12-3, sir.
Please, my
Sir,
lord.
12-3,
How do, madam?
sir, 12-3.
Grateful, my lord.
For 40. 40.
Lord, I beg to, my lord, appear on behalf of the appellant. My lord, this is a commercial dispute, my lord. A money suit was filed by the respondent herein for 2 crores. Your lordship may kindly turn to page 17, my lord. That is the order passed by the commercial court.
No, sir.
2 crores 14 lakhs 7,584 is the page 64, my lord.
Yes.
My lord, the appellant herein was who was the defendant before the court below. He, my lord, is in the business of, my lord, he's got an app, my lord, called as Daily Hunt. This app, my lord, which is called as Daily Hunt, is in the business of, my lord, taking all the news from various channels, and it's a news aggregator. Now, my lord, for this app, we entered into an agreement with the respondent herein to do marketing. My lord, once the agreement was entered into, there are on four occasions, my lord, we had given them the order for marketing in respect of this app called as Daily Hunt. In respect of two orders, my lord, we have already made the payments. Now, in respect of the third app, there was a dispute, my lord, between the appellant and the respondent, because if your lords may kindly turn to page, my lord, 40, the reasoning, my lord. Page 40.
Yes.
My lord, the monetary consideration, my lord, is based on the genuine, valid, and actual downloads, my lord. There is no dispute about that fact. Now, the dispute was whether the downloads which were done on the behest of the respondent whether it was genuine or not was the question, my lord, where there lied a dispute. For that, my lord, there is one more app which is called as, my lord, page 42, if your lords may kindly see, called as apps flyer. This apps flyer, my lord, gives a letter saying that which are the genuine apps, which are the bought-up apps. There is no dispute, my lord, that apps flyer was the app which has to give us a letter saying that which is a genuine app, which is a disputed, which is bought-up apps. Now, my lord, the letter was issued by the apps flyer, who, my lord, goes into the fact that which is a genuine app and which is a bought-up app.
What was their this thing?
I'm sorry, my lord.
What was their?
Yes, they, my lord, they have given a letter saying that there are several downloads which are bought-up apps. Now, the court below, my lord, has stated if your lords may kindly see the issues which were framed, my lord, which is at page 26. Page 26. The third issue is whether the defendant proves that plaintiff has raised invoices by including fraudulent transaction.
Yes.
My lord, my first submission would be, it is the duty of the plaintiffs, my lord, to prove that, my lord, the bills which were raised were in accordance with the terms of the contract which was entered into. It was not the duty, my lord, which was cast on the defendants to prove it. He, my lord, cannot just by submitting a bill say that, my lord, I am liable to pay certain amounts. For that, my lord, if your lordship may kindly see, why, my lord, I am not in a position to prove it is because the entire key and lock of this app is with the plaintiff, and he agrees to it, my lord, in his evidence.
Yes.
If your lordship may kindly turn now to, my lord, page 42.
But what was your case on these fraudulent installations?
Yes, my lord. Fraudulent installations, they gave a letter, the apps flyer gave a letter which is marked as exhibit P34, saying that there is post-attributable frauds which have been found out. Therefore, no payment can be made to those downloads which have been done.
No, is it their case that these were fraudulent installations?
Yes, my lord, that is the reason, my lord, we have not made the payments. Now, my lord, if it is a genuine downloads, we have no problem in making the payments. This is, my lord, when we give it to the marketing service, these are all.
And in terms of the contract, fraudulent installation, they would not be getting any payment.
My lord, there is no terms, there is no contract as such. We are just given an order, but in the evidence of the plaintiff, they say, yes, we are bound by that. If I may show, my lord, in the impugned order itself.
No, is there any express contract?
No, my lord, there
That
is no express
fraudulent
contract. There is no express contract, but
silent on that.
Yes, that is silent.
But in their evidence, they say so for fraudulent installation, they would not be entitled.
Yes, Mal. Yes, Mal. That is our case, my lord. And that has been called out in the impugned order itself. If I am able to show your lordship. Para 21, my lord.
Just say that we will issue notice, let them come.
My lord, only my humble request is, my lord, the execution is now posted on 1st of February, my lord.
Very well, you deposit the money then.
My lord, my case is that, my lord, I am not liable to pay for the fraudulent.
Very well, you may succeed ultimately, but we are in a money decree.
Yes, my lord, if I am able to show, my lord, it is their own case. Now, if I am able to show in the evidence, my lord,
Very
may I,
well.
my lord, for a minute, if I will take a lordships to that, my lord. Page 21, my lord.
No, you deposit 75%.
My lord, since I will just submit this, my lord, since they themselves.
Very well, then you take a notice, serve them.
My lord, since execution is there, my lord, I will deposit it before this honorable court, my lord.
That's right, deposit before the court.
Yes.
We will stay the execution.
Yes.
Just say that issue
If I may
notice.
request for a smaller amount, my lord.
No, nothing doing. Oh, just this is. Yes, this is issue notice to the respondent returnable on, subject to the appellant depositing 75% of the decretal amount computed as of today with the Registrar General of this court within 6 weeks. There shall be a stay of the just say that at the outset, learner counsel for the appellant submits that the respondent has initiated execution proceedings seeking execution of the impugned judgment decree dated so and so in form OS number so and so. Okay. Then subject to the appellant depositing this, there shall be a stay. The amount deposited shall be invested in an interest-bearing FDR with periodical of a nationalized bank with periodical renewals till further orders. Okay. That's it. We'll issue notice on that application also.
I make a request for 50% at least, my lord.
Pardon?
May I request for a 50% of the total amount at least, my lord?
75. The money would be in the court only.
Yes, my lord, we are in the, my lord, business person, my lord, there for them paying more than 2 crores will be.
Very well, we'll say it first, deposit this. Next.
21-4, serial number 41. 41.
For the appellant here, my lord. My lord, here, the appellant filed the claim petition before the sole arbitrator, which is awarded, my lord. Later, the respondent approached the district sessions Bhadravati for set asiding the order, my lord. Hence, my lord, before this honorable court, my lord, this commercial appeal. My lord, here the appellant is carrying business of pig iron or business with the respondent's company, my lord. Worth of 90 lakhs, my lord, deposited through RTGS, my lord. The same relating to the that respondent sent that supplied the pig iron worth of 50 lakhs 44,000, my lord. Remaining 44 of worth of pig iron not supplied. Hence, the dispute arises between the two parties. Hence,
Just say issue notice. Notice issue? No. Issue notice.
Twenty-five 3.
much.
Serial number 42. Appearing for the respondent, my lord.
My lords.
My lord, senior is on his legs on another court, but however, there's one small submission to be made.
My lords, I would.
I've been
Memo, I
received
was
with the
unable to-
inventories what they've submitted.
Yeah, I am.
Just take that.
My lords,
Just
that's
in the
the-
inventories.
Yes, yes,
my
my
lord.
lords. If I may break it
If
down,
I
my
could
lords.
make my submissions.
Yes.
My lord, if my lords could see the inventories that they have produced, they have not given any invoices, or there is no data which is given to us to show that these inventories were bought prior to the interim order. The BOE, what they have given, is also dated much later. The BOE is 1712.
My lords.
So my only request is let them place on records the invoices or the GSTs which was placed, so that we will also be able to understand if these goods were bought prior to the interim order or after that. That's the only reason which is there. That's
My
not
lords, if I
produced.
may make small submission, my lords, the interim order, the Honorable Trial Court clearly stated allowed in part. There was no bar on import. Nevertheless, my lords, the only consignment that has reached India, I've given a letter issued by the Customs Department. This arrived on 17/12/24. This is there along with my memo itself, my lords. Thereafter, even this consignment also, it has been withheld by the customs. Even though there is no bar on import, the reasoning is that what will I do if there is a bar on sale?
Is the difficulty to file in invoices?
Yes, my lords, the two difficulties, my lords. One, it is the relationship with the vendor there, the price point at which I am getting it. It's a trade secret. They have also told me to keep it as a secret. One, my lords. Even otherwise, my lords, when I've made a submission, these are the numbers to this honorable court.
Yes, sir. Very well. To be
That-
see, ultimately, who has to be satisfied? They have to be satisfied.
Yes, my
You
lord.
are
Yes,
entering
absolutely.
into an understanding. So what is your claim? Your claim is whatever you have imported, that may be allowed to be sold. That's the only thing.
Yes, yes.
They should be satisfied. Whatever you have imported are the material which have come before that interim order. Then
Yes,
they will
my
permit to redact the price
Yes.
amount.
Okay.
And what you will say is the number of units which you have imported. Okay. From whom you have imported is not a trade secret.
That they are aware. That's fine.
And just only mention the number of units.
My lords.
Because here also you have only reflected the units.
Yes, my lords, these are the units. The small difficulty in that, my lords, the consignments have come in multiple bill of entries, part of which would have been sold. So I cannot specifically pinpoint from which date whatever inventory is pending.
Can you say as a general statement,
Yes.
number of units which have come before that interim order?
My lords, except the 160, which is there in entry number 2 in the first page itself, 160 units pending release from the customs. Only that has come on 17th December. The order was placed much before the interim order itself.
See the date here.
There's
My
no
lords,
layer date forthcoming.
it is evident in the second, third page, my lords, the letter given by the customs. The tree is on 17/12/2024, the date on which the consignment landed in India.
Does this consignment includes 264 units?
No, 160 units, my
These
lords.
264 units came in.
Much before the order, my lords.
So you should say, how do we get that? On what date these 264 units had come? If I have to ask you, when did
It's-
these 264 units came, what would be your answer?
My lords, I cannot point out each unit which consignment I cannot say.
Can you state a general, make a general statement?
It's before the interim order.
Where do you say so?
My lords,
Just, he may not be even concerned with the date, on which date it comes. A statement that all these have come before the interim order, dated this and this. That's all.
please, my
Even
lords,
for the
please,
court to be
please, please.
satisfied, today we don't know when these consignments have come. If we were to permit you, or they have to agree for that, all have necessarily to be those which have come before the interim order, not after.
Yes, yes, my lords, yes,
Say,
My lords,
you don't know what is the hit.
there is nothing, my lords, there is nothing at all.
So get a
The-
proper memo or an affidavit. We want.
I'll file an affidavit itself, my lords, I'll file an affidavit itself. Which, please, my lords, I will state that. One humble request, my lords, since I'm agreeing
Be over.
yes, my lords, because businessmen are, let them focus on the business. I'll file an affidavit by tomorrow itself.
Get an affidavit
I will do it.
properly, attest
I'll
an
do it.
affidavit.
I'll do it
Yes.
tomorrow itself. my lords. I'll do it tomorrow itself.
At the request of counsel for the appellant, fill an affidavit in terms of the order passed by the court. The last date of hearing, only on the last day,
24, my lords.
on 24/1/2025. Denotify.
Please. my lords. Obliged.
Number 43.
Plus for the respondent in this case, please, Manoj. Manoj, the understanding was the matter will be heard on merits. Manoj, a small little issue is involved, please, Manoj. Well, small issue is involved.
That's true.
Whether the boundaries prevail, over the measurements. That is the
And
only
we are
issue.
ready to argue the matter any day, if your lordship is now.
Page 371 of the paper book, may kindly
We have the,
to.
we have the fact that we are the.
That
It
is
will not be possible. A date may be given, we will argue the matter.
Unless this is
When we
filed
are
in the month
30.
of April. In the month of April, it is
It
filed.
is a new appeal, sir. Why you are saying that?
This crosstalk goes on.
I'm sorry. Appeal.
Yes. Which page you said?
371, please.
Appeal. Appeal memo.
Sketch. I'm sorry, please, Manoj. 233, please, Manoj. I'm sorry.
43.
233.
Number 3.
Sir, it is. Sir, it is list of authorities.
Paper book, please.
So what does it say?
Manoj, this is a sketch, please, Manoj, which is admitted by both the parties.
Does this,
Manoj, the property 28/2 belongs to the plaintiff, the appellant herein. Manoj, on the left-hand side is my property, towards the western side of 28/2. Manoj, in between there is a road.
the dotted line is the road.
No, dotted line, please, Manoj, is the suit schedule property.
No, between 28/1 and 28/2, there is a line.
There is a line,
That is
please,
the road.
Manoj. There is a line, dotted line, please, Manoj, is the B schedule property, the property in dispute, please, Manoj.
We will argue the matter, sir. I am the appellate, sir.
Okay, we will have it. Yes,
A date may be given, I will argue the matter.
just it's already so and so, just re-notify the. First or second.
12-3.
Plus, the
Date
reason
be
I
on
am
13th, madam.
the reason I am asking for a shorter date is,
I am not in station next week.
my client is 84 years old, please, Manoj. He has been
Yes, no.
coming from Bombay regularly, please.
In March. February is not possible, with the board, it is actually not possible. Just give it.
Don't, Raghav.
Oblige.
Next.
44.
Appearing for applying.
We'll have it some other day.
My lordship, notice has to go, my lordship. Yes. My lordship. The suit of the plaintiff was,
Other side,
no, my lordship, notice not yet ordered.
for the issue.
My lordship, issue is this, my lordship, the partition suit came to be dismissed on order 7 rule 11 application, my lordship, without there being any evidence, my lordship.
Issue notice.
Much.
15-4.
45,
45 adjourned.
46.
46.
My lords, I appear for the appellants in this matter.
We'll have it some other day. We'll notify shortly, so and so, we'll notify.
26-3. Serial
Much
number
obliged.
47. Sri Ravi HK. 47. 2-4. Serial number 48. Sri V.S. Nayak.
2-4.
48.
47.
47-2-4, sir.
2-4.
April 2nd.
Next.
48. 7-4. Serial number 49. Sri Prakash.
Appellant.
8-4. Serial number 50.
Appear for that.
Just be notified.
8-4. Serial number 51. Sri
I'm
Amaresh.
appearing for the respondent. Matters pertain to pension, my lord. Short question is involved.
Possible today.
We will take it on 4th February, minutes. 4th February.
Not possible, Mr. Andre.
Any date, minutes, your lord.
We'll give you a date.
A short question is involved, my lord. It may not take much time. Any,
Thinking so, it will not take, we had on the board. We'll give you.
After
we'll give you
start-
time.
7-3.
Grateful.
can it be little earlier, my lord? Pension, my lord.
Possible, we know what is the position of the board. Let's take a chance on it. Next.
52 adjourned. 53.
Respondent. After final hearing.
For the appellant minutes, in this case.
Be notified.
16-4.
So and so, be notified. Paucity of time.
54. Party
Appellant.
person.
We respond. Same.
9-4. 55. Surana.
For appellant.
9-4.
9th of April, sir. 9th of April, sir.
It is too long, my lord, because trial court execution is there.
March. We have been
17-3.
Huh?
17-3.
17th March.
15 March, sir.
Okay.
55.
My lord, we want it
For
to be.
appellant.
Oh, yes. You can do one thing. Possibly when the matter is listed on that day, just remind the court, possibly you are appearing in person, we can take up also.
Okay.
But in the presence of, you are the respondent?
And for the respondent, yes.
Yes, remind us.
In the, early hours section. Yes, yes.
55.
For appellant.
Be notified.
17-4.
56.
56. 21.
We'll have it some other day, ma'am. 57 also.
21-4. 57.
also.
22-4. 58.
57, I am the respondent here, my lord.
We'll have it some other day.
Only one small submission.
Yes.
This is a very serious matter. After retirement, he has been dismissed from service only to deny the benefits. He is physically handicapped, missus is a cancer patient. They are struggling for survival. 60 lakhs has been withheld.
Have a short.
I appear for the appellant for this matter, my lord. 57.
No, they come and ask, they never come to the court, they ask adjournment like this. They have taken the appeal and they come around troubling me.
We are adjourning it, please. We don't.
Much obliged. Give me, kindly consider giving a short date here.
Okay, short date,
28th February.
28th February.
Much
Please,
obliged.
please.
Much obliged.
57. 57.
What is this
That
number?
was in 57,
Sir, 50. That is 57, sir.
58.
58, 23-4. 58.
You are in 58, just give it.
58, 23-4, madam. Great. 57.
List number 2.
Sir.
We'll listen to the few more.
Yes, sir.
Just call those people.
List number 2, serial number 1.
Bring for appliance.
My lord, a delivery warrant has been issued. My lord, I am claiming them.
There are objections in the registry. Objections from you.
They did not mention. Other side, respondent.
Yes, you have to remove the objections first.
My lord, that I will do it tomorrow itself, my lord.
We want the objections to be removed first. We don't know where is the interim or where is the impugned order.
Impugned order is not yet given to me.
Appeal, is this an appeal? We don't have an impugned order, we don't have a court fee, we have so many objections. And the matter is mentioned and saying that
I
an
don't know.
urgency is shown.
What is
What
that?
is
You
this?
have to.
We will not take this. We take the counsel on the face value. I'm surprised when we saw that everything is an objection. The impugned order is not there. What are we to look into?
See, we have to remove the office objection of the
If we
file.
remove the office objection, we will have it.
My lord, kindly have it, my lord, day after tomorrow. Because, my lord, the delivery warrant has already been issued.
We appreciate that's the reason we have allowed it. But when we find there is no interim, there is no impugned order, what are we to look into? Can we?
I understand, my
Can we
lord.
call it as an appeal? And mentioning is made. Remove the office objection, file the impugned order, we want to see it, file the court fee. Everything need to be on record.
No, I have been told that court fee has been paid.
Very well, they have paid it. There is no interim impugned order. We were looking for it. Where is the impugned order? What is the urgency?
Impugned order, my lord, is we have applied for certified copy. It has not been issued. But-
You can know the contents, get it typed, place it on record, seek an exemption from filing the impugned order. That can be done.
Certified, yes, it can be done.
So we will see, we will adjourn it. We will go only on Tuesday. not
Next,
Before that,
no, next Tuesday.
Tuesday or Wednesday rather. 5th.
In the meantime, status quo,
We will not. So we just say this, you have served the other side? Is the caveated appearing?
gave it till.
Very well, we will know, we want the, just say this, we find the registry has notified 6 office objections. The senior counsel appearing for the appellant states, the same shall be removed when within 3 days
3 days.
from today, list on 5th.
In both the cases.
The other one is also connected,
Okay. Yes,
same order. Shall we?
Madam. Madam, serial number 56 and 58.